This meeting is being like I got it. Hey, on YouTube. It's that it's
Jacob on.
live stream is right. I
Actually, first ಇದು ಮಾತ್ರ ಲೈವ್ ಸ್ಟ್ರೀಮ್ CH1 ಮಾತ್ರ ಈಗ ಎವ್ರಿ ಕೋರ್ಟ್ ಎಲ್ಲಿ
Yes. Next date of. Yes, give memos. I think 17. Just a minute, sir. Just a minute. Give the memos. Public premises act. Yes. When? Tomorrow.
The super specific performance lordship and the exported judgment are challenged. Commissioner one will issue for tomorrow.
Tomorrow.
In this matter, the respondent will take an execution petition filed.
When will be the execution petition?
Then tomorrow they are given the date, and this is also will give it tomorrow.
Tomorrow. Yeah, Monday. Take Monday. Mondays. Yes. Which one? Nothing will happen next week. Next week. Very well. 17th. Have it on 16th. Have it on 16th. Extension of implement tomorrow. Get ready for merits also. Yes, sir. Yes, tomorrow. Tomorrow.
Number 56. So respondent is constructing the property.
Respondent is constructing the.
Property. So invite food schedule property. So in spite of the temporary injunction order. So
You file contempt.
No, I filed contempt also.
You file contempt. When you file contempt, why you have to move the matter?
Give me a file. Dear against is also dismissed.
Yes.
Monday.
Monday. Yes, Monday. I have it on Monday. Tomorrow. Tomorrow take this. Take tomorrow. We will see. Because large number of matters will be, I think, listed. See, every day we used to get 60 to 70 memos. That's it. Next day. Let us we will see. Yes, sir. Yes, sir. What stage? Have it on 15th. Have it on 15th. Delivery warrant for tomorrow then. Tomorrow. Just a minute. Serial number 50. Very. Just a minute. Page wise. Page wise.
Page number 4, 18 and 19.
18 and 19.
Page number 5, seal number 20 to 34.
20. Why minute? First it's order 6 rule 17 matter. At the request made by the Lana Council appearing for the petitioner, list on Monday. Yes.
Page number 6, seal number 35 to 42.
35
Serial
to
number
40.
Serial number 36, my lords, I'm appearing for the petitioners.
Yes.
My lords, I require 1 week time, my lords. There's a personal inconvenience, my lords.
At the request made by the Lana Council appearing for the petitioner, list next week.
Much obliged, my lords.
Have it on next week. Please. Very well. 16. 40. 42. Yes, sir. At the request made by the Lana Council appearing for the petitioner, list next week.
Page number 7, seal number 43 to 49.
49. Yes, sir. You are appealing for the petitioner. Sorry. Serial number 49 ali. Lana Council Sri S.C. Shiramu submitted that he has filed power on behalf of the petitioner. Registry is directed to. Yes, sir. Registry is directed to print the name of Sri S.C. Shivaram representing the petitioner. Yes. List It's a 2015 matter. List next week. List next week. Call the matters.
For order, C number 1. Anand Kumar Singh.
Yes, sir. 1 minute. What is on merits? No. Where is your file? No. Where is your file? No progress. No. Very well. Of course. And a counsel applying for the petitioner seeks 2 weeks time is granted to take steps. And a counsel applying for Mr. So-and-so submitted that he is representing on behalf of the petitioner. List this matter tomorrow. See this, just you tell.
Number 2, I am for the petitioners in this case, my lords.
Yes, sir.
My lords, in a suit for partition, lordships. I have filed an application under Order 6, Rule 17,
Suit?
lordships.
Suit for?
Partition, lordships.
Where is the impugned order?
Lordships. Page number, lordships, 23 onwards, lordships.
23. Yes, sir.
Yes, lordships. I have
Yes,
filed
sir.
an application seeking to add certain grounds, lordships, where the respondents here in lordship were the defendants. Lordship, without the knowledge of the petitioners, lordships, they have inherited certain property, lordships. Those transactions which I want to include.
That you can include in final decree proceedings also.
My lords,
If you have left out any property in the partition suit, that you can
Yes,
add
ye-
in the final decree proceedings also.
lordships, now there is no difficulty with the court to lordships allow this applicant to impede lordships because
Not
it avoids duplicity of proceedings as well.
The finding recorded by the court, please go to para 9, page 27.
Yes, lordships. Yes, lordships. Further,
Please read.
the names
Please.
found in the proposed amendment, that is Parvatamma, Punit Kumar, Lohit Kumar, and Mamata, not parties in the present suit. It appears only to, they say that it is only to protect the case on the lordship. Lordship, kindly see my
Yes.
priors, lordship, in the amendment application. Lordship, there are various
Yes.
transactions without
Very well.
the knowledge of the. Yes, lordship.
Very well. That you can, this is IA number 33, that you can include even in final decree proceedings, take down. That you can add it. This petition is filed by the plaintiff number 226, challenging the order dated (23/4/2019) in OS number 9003 of 2003 on the file of the City Civil Judge, Bangalore, dismissing the application filed by the plaintiff on IA number 33. The brief facts of the case are that the petitioners herein
Right.
have filed a suit in OS number 9003 of 2003 on the file of the trial court, seeking relief of partition and separate possession in respect of the suitable property. The defendants entered appearance and filed written statement and contested the matter on merits. In the meanwhile, the plaintiff has filed IA number 33 under Order 6, Rule 17 of CPC and sought to incorporate certain properties in the suit schedule properties of the suit, and as such, the said application was resisted by the defendants. The trial court, after considering the material and record, by its order dated 23/4/2019.
May I intervene, lordship?
Yes.
My lords, this I have not sought for inclusion of any property, lordships.
Yes.
There are certain transactions which has happened with respect to the
Transaction,
social property.
that also that you can, yes.
Yes, your lordship.
Property/transactions. Property, certain property/transaction. Full stop. And they said, so and so dismissed the IA number 33 filed by the plaintiff. Feeling aggrieved by the same, the plaintiff has preferred this writ petition. I heard Sri Hemant Kumar Deal and a counsel appearing for the petitioner contended that at the time of the filing of the suit, the plaintiffs have not brought certain transaction which has been made by the petitioners and the respondent insofar as the suitable property. Accordingly,
Only respond. Only respondents.
with the respondents, accordingly sought for interference of this court. Having heard the Lana Council appealing for the parties and taking into consideration the finding recorded by the trial court on IA number 33, it is not in dispute that the suit is of the year 2003 and the said application for amending the plaint was filed on when it was filed?
It was filed on Lordship.
Filed on 16/1/2019, and the
Yes.
and the trial court, having taken note of the proposed amendment that has been taken by the plaintiff, has held that the said proposed amendment is not required to adjudicate the matter effectively. Full stop. The trial court at para 9 of the judgment of the impugned order has held that the proposed amendment is not bona fide in nature and is unnecessary in nature for determining the real issues controversy between the parties. In that way of the matter, I do not find any merit in the writ petition. Accordingly, the writ petition is dismissed as devoid of merits. Yes.
Lord, I appear for the petitioner in this matter.
Yes.
Lord, steps have been taken on 4/1/2022. my lord.
What is on merits actually?
Lord, earlier, my lord, one
Who are you?
Honu Ramma, earlier, one Honu Ramma and B. Alipir Saab had filed an execution petition against the petitioner herein, seeking to execute
Yes, sir.
an order or an award passed in an MBC proceedings. During the pendency
Correct,
of the said execution proceedings, B. Alipir Saab passed away and his alleged
Yes.
LRs filed an application to come on record. They produced the death certificate by Annexure C in support of their contention that they are the legal
Annexure C
representative.
is the death certificate. Yes, sir.
Kindly see the spelling of Alipir Saab in the death certificate, my lord. It does not tally with the name of
Very good.
Alipir Saab in the execution petition. The names
Yes, sir.
are totally different. In the execution petition by Annexure A at page number 9, Alipir Saab's
Yes.
spelling is B. Alipir Saab. Whereas in the death certificate, it says Ali Fear Sahib. There is no initial also.
Yes.
Further,
Go to para 8 in page 34.
page 34.
Yes.
In this case, PW1 was cross-examined by judgment
PW1 was
data.
cross-examined by the judgment debtor, and it is only emphasized that yes.
Death certificate produced is not pertaining to Alipir's and taking advantage of spelling mistake in death certificate. They are contending that applicants are not the legal representatives of deceased decree holders. But G3 produced that exhibit P2 clearly make out that they are the legal representatives of deceased decree holders. Since the scope of the court to decide this application is limited, the contention of judgment debtor is not acceptable and they are bound to satisfy the decree.
Yes.
My lord, may kindly see the death set, the genealogical tree which they relied upon is a genealogical tree prepared by them to suit their convenience. The genealogical
Yes.
tree is at page number 37.
Yes, you can
It is an
cross-examine.
affidavit.
Anyway, you cross-examine him. You
Yes, my lord.
cross-examine him.
Cross-examined him.
Yes.
We have cross-examined and we have specifically put a suggestion saying that the death
What
certificate.
is the suggestion that you put to him?
My lord, the trial court has observed at para number 8 itself. In
Yes.
this case, PW1 was cross-examined by the judgment debtor and it is only emphasized that death certificate produced is not pertaining to Alipir Saab. The
Yes.
stand has been taken that, however, the trial court does not give any reasoning so far as the difference in the spellings as well as the permanent address of Alipir Saab.
Yes.
Kindly see in the execution petition, the permanent address of Alipir Saab is shown as Hiriyur town.
Address may be changed.
Whereas in the death certificate, the permanent address is Bangalore. The name itself is not tallying. Initial is not there. And the spelling is Alipir Sahib.
Take steps.
Steps have been taken, my lord. Steps have been taken on
Then a counsel appealing for the
4/1/2022.
petitioner has submitted that he has taken steps insofar as unserved respondent number 1 to 5 is concerned. Registry is directed to verify the same.
Interim order may kindly be
Same
extended.
order granted earlier extended till next date of hearing.
Great, sir. Great.
2 weeks time is finally granted to comply with the office objection. Failing with the writ petition shall be dismissed without reference to the bench.
Seal number 5, Shweta Ravishankar.
Same order.
Seal number 6, DS Osman.
My lord, I appear for the petitioner.
No, you comply
The
with the
petition
office
becomes
objection.
infructuous by
Infructuous.
virtue of the matter being settled between the parties before
Yes.
the trial court, your
When a
lordship.
counsel appearing for the petitioner submitted that the parties to the list have settled the matter out of court, and accepting the submission made by the Lana counsel appearing for the petitioner, writ petition is dismissed as become infructuous. Six.
Grateful, your lordship.
Fine. Shweta. Ravishankar. Yes.
Seal number 6,
6.
DS Osman.
2 weeks time is granted to comply with the office objection. Failing with the writ petition shall be dismissed without reference to the bench.
Seal number 7, Manjula N.
No representation on behalf of the petitioner. Let this matter day after tomorrow.
Seal number 8, IATPS.
Yes. Padi. What is on merits of the case? Need not be. See, what is on the merits of the case? No. No, today is a good day. Passover? No, Passover, I can pass it over, I can take it up at 2:30. At the request made by the Lana counsel appearing for the petition, list this matter day after tomorrow. Monday. No, today, otherwise. But tomorrow, I think other matters are there. Monday, put it on Monday. The short question involved is that to dispose of the matter. Supreme Court? Yes. Yes. Heard the Lana counsel appearing for the petitioner. Petitioner sought for following relief. Page 15. Having heard the Lana counsel appearing for the party petitioner and taking into consideration the writ papers, the executing court is directed to expedite the hearing insofar as expedite the hearing and complete the entire proceedings within 8 months. Within 8 months from the receipt of this order. Accordingly, writ petition is disposed of. Very good.
Number 10, Validity K.
Yes, sir.
I have sought inquiry to number of judgments before the side. The subsequent purchaser has right. In one of the judgments they have said whether the right is substantial or peripheral. Suppose the right is substantial. Suppose the right is substantial. Then we have right to defend it. What has happened is my vendor have not defended the suit.
Yes.
The defenders filed a suit for declaration.
Suit for declaration.
If my vendors don't defend the suit, and subsequent purchaser after I get to about the suit,
Yes.
I have sought inquiry.
Yes.
Court has rejected the judgment received.
Yes. This application was filed when the matter was posted for final argument.
So,
And the suit is of the year 2014.
yes, even that the Supreme Court clarifies on that issue. Whether that this is this important point. And this is not the reasonable order.
Yes.
Looking at the proposition of non-vendor form, it is well applicable to the case as rightly pointed out by counsel for couple of previous occasions. The matter is a procedural counsel. The defendant managed to drag back to way one way or the other. That is the defendant. I am the impediment. But when he exhausted all time, now come up with this application. It used to be noted that suit filed in 2000. Applicant claims that he purchased the suit property. From defendant in the year 2000. Material record reveals that even the defendant of the sold the property to the defendant. Hence, neither defendant number 11 nor the supplicant has any independent right to contest. This is a wrong proposition of law.
Correct.
For the simple reason that they step into the shoes of the head of the court. Since doctrine of dispendence is applicable to the petitioner, he is neither proper party nor necessary party. Added
Yes.
to that, because of now that NEC 2005
There's one Kasturi case is there. Kasturi, that's a larger bench decision on this very same point.
in 2005
Whether in a specific performance suit, the purchaser to the subsequent purchaser be arrayed as a party or not. That's all I want to point out.
2005 SEC, 2012 4 SEC 324.
Yes.
Para 1920. This proposition of law which the learned judge enunciated is contrary to what the Supreme Court has said.
Yes.
Para 19.
Para 90. Yes.
Such being the scope of section 52, two questions arise whether a pendant type of purchaser is entitled to be imputed as a party to the suit. Once imputed, what are the grounds on which he is entitled? This court on more than one occasion held that a pendant type of purchaser which imputed himself as a party defendant to the suit. Such application should be liberally considered. This court also held in this assault to suit that justice requires a pendant type of purchaser should be given an opportunity to protect us. Because a case where the property dispute has been mortgaged by another does not. Mortgaging filed a suit, paid a delay, commenced proceedings for sale of mortgage.
Thereafter, it was referred to the larger bench. These are all the two judges' bench.
There
It
is
was-
some divergence of opinion. NEC 22.
Yes.
The preponderance in opinion of this court is that a pendant purchaser's application for impedance should normally be allowed. However, this, what the trial court says is, the pendant has no right at all, and he is neither a proper party nor a necessary party.
Yes.
It's contrary to the judicial.
Yes, sir. Yes.
In one the judge,
Judge.
2005, 11 is. Okay.
This is 2012.
This 2000.
What's the latest law on the point is actually?
But in one subtle distinction is, 16 and 17.
Yes.
Court says where right is substantial, then he has to be made. That 16 realized.
So it may be made at any stage of the proceeding.
Yes. And doctrine of dispendence, 16 number. I'll just read that sentence. But the answering pendant can be added as a proper informal party. If his interest in the subject matter of the suit is substantial and not just. So substantial and the entire property they hold. But apart from this, in Velu Swami's case, just refer to the
Yes.
Velu Swami's case of the Supreme Court, para 15, court there considers one
This
issue.
one judgment by a larger bench by Kasturi. That is the judgment actually. It has distinguished all these cases. I remember right. Kasturi and all.
Para 15,
No, that judgment has been not. It's latest. It has been 3-4 years back.
reconciled all
We
the.
consider all these judgments
If you want us to examine that.
better. That's a because that's a 3 judges bench.
Your Lordship.
These are all 2 judges bench. This aspect has been considered by the full bench. Actually.
But what I'm seeking is, I'm going to fix that we will permit it to depend.
Just a minute. You give the judgment. You give the judgment. Whether he may be the subsequent purchaser be arrayed as a party or not. So this is also 2 judges bench. This is all 2012. Yours is 2005, 12, 13. That is 2017.
We will get that.
It's Kasturi. It's start Kasturi versus so.
We will get.
Yes. So anyway, that is the only legal issue. So it's not on facts.
Not, 2017, the matter was posted for judgment for the first time.
Yes.
Now, when the matter was posted for judgment not in the year 2017, the 11th defendant, that is Ravi Kumar, who they claim that he
I
has
know.
sold the property in favor of the petitioner hearing. He comes on record just 3 to 4 days prior to the judgment.
Yes, sir.
But that application came to the allowed second and opportunity to be given to him. Then thereafter, Murad, he
See,
came
that is on the
record.
farm. On the legal, is arguing illegal issue.
Why Murad, why I am submitting this is, ultimately Murad, till now Murad, there is one more application filed on the ground, come on record in the same case after this order came to be passed by the court below. But he comes, files an application stating that the same.
That will be looking at in next petition, not in this.
The same Ravi Kumar.
You have any legal issue on this point? Give me the judgment.
At the time of judgment. Not for a moment, your lordship made
Like, give the judgment on this point. Any judgment?
I have not the presentation of this one also.
But
Rendered on 2004.
not 2004. You give me 2017 onwards. That's the law is
This judgment clearly says.
2007 in Kasturi case, the Honorable Supreme Court in so far as consider all these where the divergent opinions have been given, whether he may be arraigned as a party or not. Yes, reconciled ultimately the 3 judges bench. So that has to be. If you have that, I can. So day after tomorrow, sorry, Monday or Tuesday. Yes, Tuesday. Give me judgment now. Then
Monday, your lordship may have done.
Tuesday.
But Supreme Court says there is an interim order.
Get the judgment. No, Supreme Court. Yes, just only thing is pendant ticket. It may be accepted or not has to be.
All sales not of fraudulent sale deeds. I just point out to the next.
Not necessary.
Your lordship look at
Regarding whether after it is reserved the facility to be taken back. This is Ravi's very interesting observation.
It is there.
It
is there actually. I think it was referred to in other matter.
Yes, in the other matter. Para 15,
Yes.
he says, the Supreme Court says,
Yes.
need this contention is raised by extending the Karnataka Council for Respondent contended that once arguments are commenced, there will be no reopening of the Dismissal Parliament. This contention is raised by extending the convention that once arguments are concluded, the case is reserved for it. Court will not entertain any interlocutory application for any kind of. The need of the court to act in a manner to achieve the ends of justice does not end when arguments are heard and the judgment is resolved. If there is abuse of possession, the interest of justice.
Yes.
Very interesting.
That's it.
Interim order.
Yes. Interim order granted earlier, extended till next date of so Tuesday.
I will verify those.
Please. So get the judgments of recent ones. Yes.
Advocate for petitioner, my lordship.
Which order that you challenge?
My lords, it is the execution petition, my lords. We had filed an IA on 16th Feb, my lords.
Which order is challenged? Which is the impugned order here?
There are 3 connected matters, my lords. The counsel on record, Mr. Chandrakant R. Gowle, could not be present before your lordships due to a personal emergency in my lords. I request for a short accommodation.
No. You go to. Which order is challenged in this petition? You tell me at least which impugned order date. That is sufficient. I will grant you. Okay.
In WP
1763. Take any by WP. It is a stereotype of petition. Which order is challenged?
Yes, my lords. My lords, you challenge the execution order passed on 27/11/21, my lords.
27?
11/21.
Yes. Yes. Where is that in the prayer?
This is writ petition number 1763, my lord, page number 18.
Yeah. Page number?
18, my lords.
Yes, sir. Set aside the order dated 6/12/21.
There's been a mistake, my lord. That is one of the
mistake.
subsections.
Which order that you challenge? What is the impugned order?
I can request your lordship just grant us 2 days my time, my lords. We'll comply with the office
What
objections.
about the deposit? Earlier you got this interim order.
Yes, my lords. We are just waiting on the confirmation of the same, my lords.
No confirmation. It is order on 23rd.
Yes, my lords. We had filed an IA on 16th and the IA was allowed on 23rd, my lords.
Yes.
We're just waiting for the confirmation from the petitioner, my lords, if the amount has been deposited or not. Kindly grant us 2 days of time, my lord. We will give you the confirmation of the same.
List on Monday.
Obliged, my lord. Interim order may be.
You confirm it. You confirm it.
Please, please,
On
my lord.
Monday.
Please.
Waiting service.
My lords, serial number 11, my lords, I may be permitted to appear for petitioner, my lords.
Petitioner.
Yes, my lords.
11. 11
Yes,
is
12, my lords.
12. Yes.
My lords, in this matter, my lords, the trial court is posting the matter every day, my lords. My lords, grievance, my lords, kindly refer to annexure J, my lords, page 69.
What's the impugned order? Sir? What's the
My lords, order, my lords, I have filed an application for clubbing all the matters and adjudicate the same together, my lords. The respondent number 5 and 6 are filed is separate for their injunction, and the petitioner has filed as comprehensive suit for declaration, my lords. My lords, it was before the two courts, and subsequently, my lords, by virtue of the order passed in miscellaneous petition, my lords, on 8/1/2020, all the suits were posted for one court, my lords, that is additional court, my lords, at Oscote. My lords, now I have made an application, my lords, a liberty has reserved to me to make an application to club all the matters. My lords, I made an application, but learned trial judge dismisses my application on the case. My lords, kindly refer to page 97, my lords.
Yes, go to 98.
Yes, my lords. My lords, paragraph 12, my lords.
Yes, sir.
My lords, it should be noted that while considering this application, this court is not supposed to go into the merits of the suit. It should be noted that except application filed by the petitioner, plaintiff has not produced any copies of alleged original suit numbers which purpose of to club.
Proposed to be clubbed.
Yes, my lords. Further, the careful procedural objections filed by the defendant, it appears as the subject matter in the suit as well as in OS 83 and 84.
Subject matter of the suit in 83 of 2011 and 84 of 2011.
2011 entirely. Therefore, this court is of the opinion is the absence of material, proper material, mere filing of an application for clubbing is not sufficient to consider the claim made by the plaintiff. My lords, kindly refer to the application, my lords.
What is the relief sought for in 83 and what is the relief sought for in 84?
My lords, those two suits are only for bare injunction. My suit for 190 is for comprehensive, the suit for declaration. My lords, kindly refer to the plaint, my lords. I have also produced the plaint. Page,
yes.
Page 58.
In 83.
My lords, I have produced the plaint in 84, annexure F, page 54, my lords.
54, 1 minute.
Yes, my lords.
Yes, sir. What is the relief?
They are making a, yes, my lords.
What is the relief in this?
Bare injunction, my lords, in respect of my property, Kanishbari number 10. My lords, this property is to an extent of 100 and...
You go to annexure E.
Yes, my lords. Yes. My lords, 83, my lords, is for also suit for bare injunction, my lords.
No, just we see 83.
Yes, my lords.
What is the prayer in suit number 83 of 2011?
My lords, annexure E, page 51.
Correct.
My lords, page 53 is the order, my lords. Injunction, my lords.
No, 53 is not injunction.
My lords, Prativadigal ಮತ್ತು Nagaraj.
Written statement. What you are reading is
sorry, my lords. Sorry, my lords. My lords, sorry, my lords. My lords, kindly refer to page
50.
Annexure C, my lords, page 54, my lord. 44.
44.
Yes, my lords. Page 47 is the prayer, my lords. To grant permanent injunction again is the defendants from interfering with peaceful possession.
That is 83.
Defendant.
That is 83.
83. 84 is page annexure D, my lords, page 48.
Yes, sir.
My lords, this is page 50 is the injunction.
Whether the suit schedule property is one and the same or not?
Yes, my lords.
How can? See,
my lords, kindly refer my comprehensive suit, my lords. Page.
No, you read schedule first.
My lords, this is a portion. My lords, my lords, kindly refer to the cast title, my lords, page 9, my lords.
Maybe the parties may be different, the plaintiff may be different and the respondent may be one and the same. But go to the schedule in the.
My lords, scheduled is Kanishbari number 10.
Go to 47, please.
Yes, my lords.
Please read the schedule.
Yes, my lords. My lords, part and parcel of the property bearing Junjur number 313.
That is 313.
Yes, my lords. Property number 8.
Yes.
Yes, my lords. My lords, now
Stop there. You come to schedule in 84.
My lords, 84.
Junjur number 314, property number
314, property bar 9, my lords.
99.
My suit.
No,
My
property
suit is.
99.
Yes, my lords.
99 actually.
9, my lords. That is 99, Allah. 9, my lords. It should be 9.
No,
My lords.
what is there in the plaint? I have to see alone.
My lords, yes, my lords. My lords, kindly refer
I
to
cannot
my
assume.
suit, my lords. My suit at OS.
The schedule property is different. The learned judge is just.
No, my lords. My lords, kindly refer to this, my lords. Page 1, page 58, Annexure G.
Annexure G.
Annexure G is my suit, comprehensive suit for declaration, where I am a defendant in both the suits.
Yes.
My lords, this is a comprehensive suit filed by me against the defendants and the respondent authorities.
Yes.
In respect of Kanishbari number 10, my lords,
Yes.
I specifically stated that they have created the document in respect of site number 8 and 9 and making a claim in respect of site number Kanishbari number 10.
See, this is a suit for declaration. Those
Yes,
two
my lords.
Those
In
two
the-
sites are relating to the injunction and of different properties.
No, my lords, this is the same portion, my lords, same portion where they have given the separate numbers. Not they are making a they are making a documents, creating a documents.
No, you go to schedule in the third suit also.
Yes, my lords. My lords, it is Kanishbari number 10.
10.
Measured to an extent of east to west, 155 feet, north to south.
See, properties are different actually.
My lords, no, my lords, it is not different. My
You
lords,
say no. You read the schedule. See the schedule.
My lords,
You see
my
the
lords,
schedule. Compare all the schedules in all the three suits.
my lords, my case, specific case is that Kanishbari number 10, my lords, has been owned by the plaintiff, that is the petitioner herein.
Yes.
My lords are creating the schedule as per their whims and fancies.
Yes.
My lords are claiming the possession in respect of Kanishbari number 10 is
Yes.
my lords, that is pending before the the trial court.
Yes. I think the subject matter of the suit. Are
No, my lords,
different.
subject matter is the very same, my lords, because they have.
No, Bedi, please repeat this schedule, sir. Ramesh.
My lords, they have made the schedule as per their whims. My lords, as
According
per-
to not their inside. I have to go by the plaint, Alva. I cannot say. I have to follow the plaint.
yes, my lords, the
Then-
plain, the
According to you,
lords,
it may be one and the same. But I have to look into the schedule mentioned in the plaint.
my lords, it has to be adjudicated, my lords. Kindly refer to the my lords order passed.
Not a case for interest. Sorry, sir.
My lords, kindly refer to the order passed in miscellaneous, my lords, 190
Yes, sir. All the,
of 2019 while transferring the case to the
Petition.
trial court.
Yes, sir. Yes.
My lords, kindly refer to my lords paragraph 9,
Yes.
77, my lords.
Yes, sir.
My lords, under section 24 of CPC, Civil Code of Civil Procedure, this court has got power only to transfer the cases from one court to another court, and it never speaks for clubbing of the cases. Therefore, the prayer per se sought for the petitioner cannot be allowed. It is the contention of the learned counsel for the petitioner that the extent of the suit property was erroneously merged with the Kata number 8 and 9. The notation was effected in favor of respondent of 5 and 6 here, and in the fact the subject matter of all the suits is common. The parties are substantially common in all the suits. Under these circumstances, it is always better that all the suits are tried by the same judge. Therefore, transferring OS 84 of 2011 and OS 190 of before both pending on the file of principal judge and JMFC Hoskote to the court of learned additional civil judge JMFC Hoskote, where OS 83 is pending, would meet the ends of justice and the relief can be molded in terms of Order 7 Rule 7 as Order Code of Civil Procedure. Therefore, even though the prayers of the petitioner is for clubbing, modify the prayer, the suit or order to be transferred as above. Accordingly, points framed for consideration is all partially in affirmative and following orders. My lords, kindly refer to My lords, page 79. Parties are liberty to make an application for clubbing the cases if they are advised.
Yes.
My lords, based on this, my lords, I have made an application. My lords, all the suits are before the additional civil judge. My
I
lords,
think subject matter are different in all the three.
no, my lords, it is the subject matter is never different, my lords, because they are claiming they assigning the property, my lords, separate numbers into my Kanishbari number 10.
According to me, according to you, it may be identical. But in
It has to be adjudicated, my lords.
What is mentioned
My
in
lords,
the
rights
schedule
has
that
to
I
be
have to
adjudicated, my lords. If an injunction order is passed, my lords, there will be divergent findings in OS 190 of 2012, my lords.
Anyway, that you have filed a suit for declaration is a
My lords,
comprehensive.
if the learned trial judge in OS 83 and 84 decrees the suit, my lords, then, my lords, I will be restrained from entering into my possession, my lords.
Nothing will happen. I think anyway you have.
My lords, with that observation, your lordships can dispose of the, my lords.
No. Sorry.
My lords, the comprehensive suit for declaration is pending.
The plaintiff has filed this petition challenging the order dated 12th January 2022 in OS number 190 of 2012 on the file of the additional civil judge and JMSC was quoted, dismissing the application filed by the petitioner / plaintiff under section 151 of CPC for clubbing of the cases. Full stop.
Lords,
The brief facts for
my lords, can I
adjudication-
interfere for a moment, my lords?
Yes.
My lords, can I interfere? My lords, the learned trial judge says that I have not produced any document
Yes.
before passing any order. My lords, it was the duty of the court, my lords, to secure the documents, my lords, before passing an order. My lords, I may be liberty to file a fresh application enclosing the order copies, my lords.
Anyway, the order is already passed. This exercise you should have done in the beginning.
My lords, because I was under impression that my lords, suits are on the same day, my lords. It is on the same day. It is tomorrow, my lords.
Just a minute. Or that the plaintiff has filed an application seeking clubbing of OS number 84 of 2011 and along with the OS number 190 of 2012 by permitting the plaintiff to prosecute all the three suits together by recording common evidence and common evidence. Full stop. The said application was rejected by the trial court by order dated 12th January 2022 and being agreed by the same, the plaintiff has preferred this petition. See, B. Ramesh Lana counsel appearing for the petitioner contended that the subject matter of this suit in all the suits, namely 83 OS number 83 of 2011, OS number 84 of 2011 and OS number 190 of 2012 are one and the same, and the original suit number 190 of 2012 is filed for seeking declaratory relief, and as such all these suits be clubbed together for adjudicating the same by a common order. Full stop. Having heard the learned counsel appearing for the petitioner, I have carefully considered the finding recorded by the trial court, and also I have verified the schedule mentioned in all the three suits mentioned by the learned counsel appearing for the petitioner. Full stop. Schedule in OS number 83 of 2011 reads as under 47. Schedule in OS number 84 of 2011 reads as under page number 50. Schedule in OS number 190 of 2012 reads as under page 61. It is not in dispute that the schedule in all the three suits are one and the same. And the OS number 83 of 2011 is filed, OS number 83 of 2011 and OS number 84 of 2011 has been filed by the plaintiff seeking a temporary injunction. However, the defendant in the aforementioned suits has filed comprehensive suit in OS number 190 of 2012. Having taken note of the aforementioned facts, I have carefully considered the finding recorded by the trial court at para 11 and 12 of the impugned order, which clearly established the fact that the trial court has applied its mind and had come to a conclusion that the subject matter in the suit and the schedule mentioned in the suit are entirely different. Accordingly, the court declined to entertain the application filed by the plaintiff. In that view of the matter, I do not find any merit in this substance in the writ petition. Accordingly, same is dismissed.
My lords, this observation, my lords, does not come in the way of my lords deciding the suit, my lords, on merit, my lords.
That can,
Because, my lords, what happens, my lords, if they
nothing will happen. Nothing will happen.
my lords, that observation, my lords, kindly, my lords,
Nothing else. The court will decide the matter.
my lords,
It is
different
only for
properties ಅಂತ
judging.
ಹೇಳಿದ್ದಾರೆ, my lords,
No.
different
No, just I followed what is there in the schedule. That's all.
my lords, so only, my lords, if
No, nothing will happen.
for me to adjudicate in
No,
OS,
nothing will. Two weeks time is granted to comply with the office objections. Yes, sir. Yes, sir.
Appearing for the petitioner, my lord.
Yes, sir.
This case, the respondent is an advocate is served, and he represented also.
Yes, ma'am. This is relating to court fee.
Yes, ma'am. My lord, my submission of it, please.
Yes. Third. Sir, you make government as also a party
Pardon?
respondent in this. You implicate the government is also party.
It may be taken as today itself will be amended to amended. Your lordship may take it as
Yes.
a memo is recorded.
This writ petition, the issue involved is with regard to the payment of court fee by the plaintiff. First of, accordingly, Lana counsel appearing for the petitioner, seeks leave of the court to implead the state of Karnataka as a party in this party respondent in this petition. Except in the submission made by the Lana counsel appearing for the petitioner, respondent state has been made as respondent by 12 in this writ petition. Accordingly, Lana counsel appearing for the petitioner is permitted to amend the cause title. In the meanwhile, Lana counsel appearing for the respondent seeks 1 week's time to file a statement of objection.
I may be permitted to give copy to the government advocate.
Lana counsel appearing for the petition is also permitted to serve copy to the Leonard STGP. Yes, sir. List this matter after 2 weeks.
And 1 week also got to move for it. Only 1 week. I will do it today itself. My colleague will do it today. Only request.
One of 21. Interim order granted earlier extended till next set of year. One. The set aside yes. One. Okay, 1 and 2 ಎರಡು ಹೋಗ್ಬೇಕಲ್ಲ 1 and 2 correct. 1 of 21 and 2 of 21. Yes. Your notice has to go on IA 1 ಅಲ್ಲ. Issue notice on IA 1 of 21. ಕೊಡಿ. Memo filed by advocate for petitioner submitting LRs of or 11 and a counsel appearing for the petitioner was filed 2022 stating that the respondent number 5, 6 and 9 are the legal representatives of the deceased. This is for, no, first we will take a memo. Just a minute. What is, I think, memo filed by petitioner of the memo dated 9 9th July. Sorry. Better. Strike out. And a counsel appearing for the petition has filed memo dated 9/7/2021, stating that the respondent number 11 died on 30/10/2020, and the legal representatives of the deceased respondent number 11 or the respondent number 1 to 3 and 12 were already on record before this court. Accordingly, seeks dispensation of notice insofar as bringing the legal representatives of the deceased respondent number 1. The said memo is not contested by on the other side. Accordingly, memo is accepted. The respondent number 1 to 3 and respondent number 12 are the legal representatives of the respondent number, deceased respondent number 11. Accordingly, memo is disposed of. The petition has filed memo dated 10/3/2022, stating that the respondent number 5, 6, and 9 are co-defendants, and they are similarly placed as petitioner before the trial court. Accordingly, he seeks leave of the court to dispense with the notice insofar as the respondent number 5, 6, and 9. Memo is accepted at the risk of the petitioner, and accordingly, notice to 5, 6, and 9 are dispensed with. Yes. That I will say. Notice on IA 1 of 21. Interim order granted earlier, extended till next date of year. Yes. R2. Non-served cover return with post insurance in this time. But in not refused on the mark. Unclaimed that you have to take. Yes. Yes, 2 weeks time is granted. Take notice for vehicles. Notice on IA 1 of 21.
17?
Yes, sir. Yes. What is the matter, sir?
After recent I have tried application before the trial court for summoning the documents and witnesses for the purpose of examining. That has been
You sought for summon certain documents.
ಫೈಲ್
You are
ಅವರೆಲ್ಲ ಸೇರಿದ್ದಾರೆ
who are you?
ಅದರಿಂದ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅವರು
Yes,
ಮೆಮೊ
yes,
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅದು ಇವರು
sir, please mute your system. Muniraj. Yes, Muniraj ಅವರೇ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸಿಸ್ಟಮ್ ನಿಮ್ಮದು. Yes, sir. What you are the plaintiff. Yes. You filed a declaration. Now you saying that let the defendant will file certain documents.
I'm not saying anything.
You wanted to examine.
I wanted to examine what happened. OS 153 for 2014 is for declaration that the state dated 31/3/2019
Yes.
null and void on the ground that the sale consideration amount which was agreed upon as per the sale agreement
Yes.
was illegally withheld by him, and therefore the transaction.
It is your suit.
Yes,
You have
sir,
filed a suit for declaration. Then you have to prove.
I have to prove he has taken a DD in my name, and that was given a stop payment saying that has been lost. Therefore, I am.
Where you have taken this plea in the plaint?
Please, madam, in the plaint itself, I am taken all the contents.
Where?
Annexed again, madam.
Yes.
Para 2 onwards, madam.
Go to particular para. Onwards, madam. Go to particular para.
Madam, material arguments is in para 2 entry, madam.
No, where is that? Just you go to particular line. That is sufficient.
Bottom line of
Para?
defendant paid a portion of the balance consideration to the plaintiff by the 5 lakhs in the form of a demand draft.
Yes.
Drawn on Karnataka Bank.
Yes.
Limited Bangalore by the DD number so and so, dated so and so, in the name of Bhagyalakshmi.
That you can prove in the evidence. In your evidence, you can prove.
Yes, madam. This DD was stop payment was done.
Where is that? Where is that?
Madam, further I have stated, madam, in the same paragraph. Further,
Paragraph?
Paragraph.
Which paragraph?
ಇದೆ 2 para 2 ಅಲ್ಲೇ
Para
bottom.
2.
To her surprise, the plaintiff receives information from the bankers that the demand of given by the defendant, the plaintiff as towards the full and final settlement towards the sale deed of the suit schedule property pertaining to the same the defendant had given a letter to the bankers in the form of
Yes.
the complaint that the demand draft obtained from the bank for an amount of ₹5 lakhs by the defendant has been lost.
Yes.
And hence the demand draft is presented should be stopped and refused. Accordingly, when the plaintiff presented the same to the bankers for cancel collection, the demand draft given by the defendant to the plaintiff was informed of the same. This really shocked the plaintiff. What happened?
See, that has been marked as Exhibit P2.
No, that sale deed is marked as Exhibit P2.
Then?
But there is one agreement of sale dated 8/11/2010.
See, you must have laid the foundation in the plaint itself.
Yes, plaint itself. We have stated in the plaint. You last time you see the first
And
second para.
yes.
Total consideration ಬಂದಿದೆ. Total amount ಎಷ್ಟು amount ಬಂದಿದೆ, ಎಷ್ಟು amount ಇನ್ನು ಬಾಕಿ ಇದೆ ಅನ್ನೋದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
Yes.
only the SR value is shown.
Yes, sir.
And for that it has been registered. Now
How can this after sale deed that you wanted to say sale agreement?
ಅಲ್ಲ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಪಾಸ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ.
Yes.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಮೇ ಕಳಿಸಿ in the application what I am saying is whether the plaintiff has purchased the deed in my name and but that is not totally different. If it is lost, if it is
Yes. I think he has produced a sale deed, go to R1. R1.
you last mé ಕಳಿಸಿ the order dated impugned order page 36 ಅಲ್ಲಿ you last mé ಕಳಿಸಿ I pursued the pleading. This suit is filed by the plaintiff for the declaratory relief of sale deed dated 31/3.
See, you have challenged this sale deed.
No, I am not challenging. As no.
Plaintiff has
Yes,
challenged.
I have said mandatory injunction direct. You last me kindly see the tenor of the order. Null and void and mandatory injunction directing the defendant to hand over the possession of the suit. Said prayer is only based on the sale deed which is marked as Exhibit P2. But during
So that is the 31/3/2011. Sale deed means 31/1. Yes.
But during the cross-examination of PW, he admitted that the sale consideration mentioned in Exhibit P2 is paid by the defendant.
Yes.
The rest of the facts stated in the application are not proper to prove the case.
You admitted that you received the consideration.
But there is one rare sentence in the evidence saying that whether you have received the sale consideration, show in the sale deed. Well, he says, yes, that has been received. My claim, rate government itself has to be seen, which shows that apart from what is mentioned.
So this is a registered sale deed.
Registered sale deed correct.
Then
the agreement is also marked. That agreement of
it is a suit for declaration. You prove on the basis of your document.
I am proving this.
The onus is on you to prove.
That's what my effort is towards that only. I am not saying that the defendant should bring any document to prove my case. I am not saying that.
Yes.
I am saying that defendant has taken a DD in my name in so-and-so bank. I wanted the bank, the application form given by the defendant to purchase the DD and the DD copy should be produced before the court. Only those two applications I made. That's all. In respect of this 5 lakh rupees DD, which he says that has been lost.
Yes.
It is not really lost because it is deliberately has been, he has, to cheat me, he has given the sale consideration amount on the date of registration and immediately given a stop payment instruction to the bank, only to cheat me, Malad.
Whether committed cheat or fraud or something, that has to be plead and proved.
I have stated in the plaint, Malad, that entire plaint itself is that.
Then go for a trial. Not a case.
That's what I am doing. That one only in the
Not a
trial.
case.
I am
You
seeking
cannot
that-
direct the defendant to produce all these documents.
Not the defendant, I am seeking the document from the bank, not from the defendant. Defendant has said it is not with him. I have given notice to him. He said it is not with him. Thereafter, I am taking this step. So, last time I see all those documents are marked. Last time I see that exhibit sale agreement is also marked. 8/11/2010 agreement is marked. In that agreement, sale consideration is shown as 22,60,000.
And in respect of the part payment only, this 5 lakh rupees deed is taken by the defendant in favor of the state deed. And upon registration of the state deed, he has given a stop payment instruction deliberately to cheat me. That is my case. Therefore, I am saying that this is a fraud has been played upon me. Therefore, declare that sale deed is null and void. To prove that, I am seeking the document from the bank whether the defendant has taken the DD in my name or not. That is one document, and the application given by him. So that it will prove that this DD is not mistakenly taken, it is taken in respect of the very same transaction. Because when he purchases the DD in my name, he has to show why he has taken a DD in my name. Without that, he cannot escape by saying that by mistake, he said that it is being lost, but he has taken the DD in my name. Where it is registered in his name on the 31st day, and the very next day he gives a complaint to the bank saying that DD taken in my name is lost, therefore stop the execution. The DD is put to encashment through my account. Therefore, there is no question of DD being lost. Last time I can see my applications here. Application C on it. Next C to F. The last time I can first application is list of witness. That is the innocuous application from Karnataka Bank and Axis Bank. Karnataka Bank is my bank, Axis Bank is
The
his
sale
bank.
deed has been executed.
Well, the sale deed has been executed.
In the sale deed itself, the consideration amount will be passed on
That is
from.
not the correct thing. The
See,
sale
how can-
deed only.
It's a registered sale deed. How can you say it's not?
Sale deed only. SR value register ಮಾಡಿದ್ರು. That is not the real value of the property. The real value of the property is while the agreement is also marked.
Yes.
The agreement document is
Not a case for it.
no, but the agreement has been marked.
Very
This,
well.
this agreement itself
You are the
has
plaintiff.
got-
You are the
got
plaintiff.
to be-
It is a declarative suit. You prove it.
ಅಲ್ಲ ನಾನು ಡಿಕ್ಲರೇಟೆಡ್ ಸೂಟ್ ಅಲ್ಲಿ ಅವರಿಂದ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳ್ತಾ ಇಲ್ಲ ನಾನು ಐ ಆಮ್ ಸೀಕಿಂಗ್ ದ ಟೂ ಡಾಕ್ಯುಮೆಂಟ್ ಫ್ರಮ್ ದ ಬ್ಯಾಂಕ್ ವಿಚ್ ಸೇಸ್ ದಟ್ ಒನ್ ಈಸ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ಡ್ ಬೈ ದ ಡಿಪೆಂಡೆಂಟ್ ಟು ಟೇಕ್ ದ ಡಿಡಿ ಅಂಡ್ ಹಿಸ್ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಫಾರನ್
Yes.
those two documents I am saying nothing else. Those two documents will prove that this is not lost. The DD which is for 5 lakh rupees is not lost, and that is meant towards sale consideration is my case that is being pleaded in the plaint, and I wanted to prove that this is not that out of nowhere I am seeking this. You lot may kindly see from paragraph 2 onwards I will read. It is clearly brings out that plaintiff has pleaded very specifically that agreement is dated 8/11/2010. The total consideration is 22,60,000, and he has paid the amount less that 5 lakh rupees. Entire thing more than what is stated in the sale deed has been received. Only in respect of this 5 lakh rupees he has tricked me, and he has upon giving the on the date of registration handing over the DD. After completing the registration, he has given a stop instructions to the bank to withhold the payment, only to defraud me. Only that is my case. Therefore, I am seeking before the court that this sale deed be declared as null and void and restore the possession. That is my main way. And to prove my case, I am seeking two documents from a bank. One is from Karnataka Bank, while other is from the Axis Bank, where I want to prove the defendant's handwriting to show that he has taken the DD in my name only to pass on the consideration amount, nothing else. Therefore, this document is very much necessary for me to prove my case.
Yes.
And your Lordship may kindly see the order passed by the court. It says, it is the suit is of the year 2014, therefore the time has been not, therefore I am not allowing the application. My lord, this is not a reasoning where the court shall say that because of
That's correct. That's correct.
delay this cannot be done.
Yes. Yes. Totally.
You ask me this application and the opportunity for those is very difficult for us to conduct the trial. You got to make given opportunity whether that admissibility is there to be considered by the court.
The trial court has given a reasons.
But trial court has not given any reason. They said only that there is a cryptic order saying that you have admitted the receipt of sale consideration as per Exhibit P2. That is the reasoning given. Plain government very clearly.
Even he has filed the sale deed. Yes, filed the sale date as annexure R1.
ಅದು ಕರೆಕ್ಟ್ ಸ್ವಾಮಿ, ಆದ್ರೂ ನಾನು ಹೇಳ್ತಾ ಇರೋದು we have also stated sale deed ಅಲ್ಲಿ ಕಡಿಮೆ ಅಮೌಂಟ್ ತೋರಿಸಿದೀವಿ.
So you cannot
Only
say
for
that the amount which has been given, I think you have accepted that consideration what is stipulated in the.
ಪ್ಲೇಟ್ ಅಲ್ಲಿ ನಾವೇ ಹೇಳಿದ್ವಿ ಅವ್ರು ಎಕ್ಸಿಬಿಟ್ P2 ಮಾಡಿ ಅದು ತೋರಿಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಎಕ್ಸಿಬಿಟ್ P2 produced by myself. I have only stated that this is being registered for a lesser amount. The actual amount meant for the total transaction is more than what is stated in the exhibit stated. That's all stated in the plaint itself. There is nothing else to be stated further here.
Yes.
What you said is only one cryptic answer where he has taken out from the whether you have received very pointed question, whether you have received the consideration amount as stated in the stated.
Yeah.
He says naturally he has to say that there is more than that what we have already stated. Apart from that, there is more is meant to be paid under that agreement that is stated and agreement is marked only to prove that case. Therefore, I am seeking that those two documents may be barred from that.
Yes.
If that is allowed, my lord, I can be able to prove my case.
Yes, yes. Good. This writ petition is filed by the plaintiff challenging the order dated 15/10/2019. Please read, please read. 15/10/2019 in OS number 123 of 2014 on the file of the Civil Judge Senior Division and CJM Tumkur, dismissing the IA number 9/2/14 filed by the plaintiff under order 16 Rule 1 read with order 16 Rule 6 and under order 16 Rule 1 within bracket 2 and order rule under order 16 Rule 6 of CPC respectively. Please start. The brief facts for adjudication of this writ petition are that plaintiff has filed a suit for seeking declaratory relief against the defendants to declare that the sale deed dated 31/3/2011 registered before the office of the sub-registrar at Tumkur as null and void, and also sought for mandatory injunction, directing the defendant to hand over the possession of the suit scheduled property to the plaintiff. The said suit was resisted by the defendant by filing written statement. The plaintiff has adduced the evidence before the trial court. In the meanwhile, the plaintiff has filed the applications summoning documents from the respondent bank has filed an application summoning the documents from the Karnataka Bank Limited Koratagere, which has issued the DD in favor of the petitioner and same was not encashed, and therefore he sought for the documents from the respondent bank. He sought for documents from the bank referred to above. So the said application was resisted by the defendant, taking the contention that at the time of the cross-examination of PW1, the PW1 admits the passing of the sale consideration amount as per Exhibit P2, within bracket the considered amount as per Exhibit P2, and therefore, the summoning the documents from the bank does not arise at all. The trial court, having heard the learned counsel appearing for the parties and have considered the learned counsel appearing for parties, by impugned order dated 15/10/2019, dismissed the application on the ground that the PW1 in its examination, has mentioned admitting receiving the consideration amount as mentioned in the Exhibit P2, and in that view of the matter, as the PW1 himself has admitted the evidence insofar as receiving the consideration amount set out in the sale deed dated Annexure R1 ಅಲ್ಲ sale deed dated 31/3/2011 within bracket annexure R1 filed in this writ petition, filed along with the statement of objection, I do not find any merit in the arguments advanced by the learned counsel appearing for the parties. It is a parties. Accordingly, the writ petition is dismissed.
Preliminary hearing, Karnataka.
Yes, sir. Yes. 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 What is the reason given by the court?
There is delay in filing that. There is no such delay.
Yes. So compromise petition was accepted, signed by the parties.
Our this one is that there is a fraud claim by the plaintiff. The source was specific for fraud.
Well, you accepted. I think you have signed the documents.
There is insertion. Further sale consideration was not paid. And in the compromise, it was said that I should be paid more amount. But that was not, I just referred to that affidavit itself.
When was the compromise petition was accepted? 13. When was the application is filed?
Execution in the year 2015.
No. 2013. So after lapse of 2 years, now you wanted to reopen.
The question is that, kindly see annexure E page number 49, wherein page number 50.
20?
My main question comes there. And
Yes, sir.
was compromise petition filed.
So compromise petition is page number 51. 51. Annexure E.
Already, the defendant have received the entire sale consideration from the plaintiff. That is insertion with the plaintiff.
Yes.
Although it is early, they took a cross their signature. The petitioner was 70, 74, 75 years old.
Of course, you have also signed the document.
Because he was not aware. The advocate himself has was examined before the court.
But you have signed the compromise decree.
The compromise is, but insertion was
Insertion for also that you have signed.
The insertion was
Even for that insertion also you have signed.
signed until they took a signature.
No, they did not took. You signed it.
Signed it until
Or see, both are one and the same. I'm passive. You are.
Insertion was not within the knowledge of the petitioner.
How can you then side in the side ಅಲ್ಲಿ ಹೇಗೆ ಸೈನ್ ಮಾಡ್ತೀರಾ? ಸೈನ್ ತಗೊಂಡಿಲ್ಲ, ನೀವು ಮಾಡಿದ್ದೀರಾ?
I may refer to the evidence of the advocate who represented the plaintiff.
Yes. Yes.
That is annexure L, page number 82. Annexure L. Our that was not at all. Compromise ಆಗಿದೆ.
Issue notice. Issue notice. No, nothing. In fact, ಇಲ್ಲ. Issue notice. Issue emergent notice. Learned counsel appearing for the petition is also permitted to serve copy to the learned counsel representing the respondents before this court in the trial court. Yes, sir.
Execution petition of 10 of 2015.
Yes, sir.
For a limited period.
Wait. No, not that cannot. Nothing will happen. Nothing will happen. You are also you will get it. See, you have signed it and before a court itself. It was signed before a court. Next matter. Seal number 19. Yes. Yes. Who appear for others? You are representing. 2 and 3. Can I give time for them? So when you are likely to file?
Both are connected. 17th or 18th. 17th, yes.
Any day of your choice. Sorry. Mr. So and so. Or ಹೆಸರು ತಗೊಳ್ಳಿ. Mr. So and so. Oh, you are the petitioner. In that order 6 rule 17 is allowed. Mr. Ashok Kumar BG, then a counsel appearing, then a counsel submitted that he has been instructed to appear on behalf of respondent number 1 and 3 in WP number 19597 of 2021. Full stop. Full stop. Submission is accepted. Registry is directed to print the name of Mr. Ashok Kumar BG in the cause list. List this matter on any day of your choice. Yes, 22nd. Interim order granted in ಎರಡರಲ್ಲೂ ಇದೆಯಾ ನಿಮ್ಮ second case ನೋಡ್ಬಿಡಿ interim order where there is interim order is extended till next topic. Yes. Yes.
This case I am appearing for petitioner, my lord.
Issue emergent notice. Let us please.
Non-filing of return statement. Recently, on 28/2, the defendant number 3 return statement allowed by the court on cost of rupees 4,000, my lord.
Issue emergent notice.
Stay may be granted, my lord. Otherwise, the
you approach the court lately, you have some at least mental support. Issue emergent notice.
The trial court has taken the attachment of mobile in the VC commissioner. I will submit regarding that.
Yes.
The injunction petition was filed.
So who are you actually?
I am trial court. I am responsible.
You are the JDR number 2.
JDR number 2.
JDR number 2. Yes.
25/3/6 months. The dismissal is not constitutional 25/4/2019. After the lapse of the 5 years 2 months, the trial was allowed from the restoration of the execution petition management.
Yes.
The bar verification management, there is no the finding under section 159(1) in order for they cannot do management.
But they say that the decree orders are not entered for interest for the set period. The trial court has come to a conclusion that the decree holders are not entitled for the interest for the set period.
Interest only management. Because what if they are already taken attachment management, that is given commissioner management. No, correct management.
1 minute.
Now has taken the steps.
Saying something. Correct. It is there in the interim, yes. Yes, we will hear this matter. Let us take it.
Data part not for data for knowledge management. That is I produce the citation and included management. However, they are taken the my steps in the commissioner management, DPP commissioner, management. Therefore, the kindly stay the arrested at least management.
Not you are appealing for sir? Mr. P.V. Chandrasekhar, then a counsel submitted that he has been instructed to appear on behalf of the respondent number 2. He seeks 1 week's time to file power. Full stop. Issue emergent notice to R1 and R3. R1 and R3 is governmental, special government. Then at SCGP accept notice for respondent number 3. Issue emergent notice to R1. Let us take it up.
They have already taken this attachment management.
When will be?
Last date already they have taken the attachment management.
You deposit the amount so that.
Already they have taken the attachment management.
You deposit the compensation amount.
At least 20% I will deposit.
Not 20. No, this is BB. This is BBMP. You know.
50% management. 50% management already taken the attachment management. Commissioner itself they have taken the attachment.
Very well.
These are public money management.
That's why you deposit public money. You deposit the money, I will grant you.
50%
I'll deposit my lordship.
You deposit.
There is a merit of the case file. Whatever mention how it should be condemned delay, there is a order of the court, my lordship.
That's why you deposit the amount what is claimed.
There is no inner power. Where is the inner power of the judicial court to allow the power minus 151 section CTC, my lordship? Where is the inner power of the court as cannot restoration in the
You deposit the amount, I will grant a stay.
50%, my lordship.
That cannot be. If it is a private individual, we can say 50%. It is a BBMP, you have a statutory duty. No, you deposit the entire amount. Your entire amount. If it is a private individual, if you have stated 50% or if you succeed, you will get back your money. That's why you deposit the entire money. That's a different thing. You deposit. That's why I wanted to safeguard the public money. Instead of you, better it should be in the court. You got my point. Better it should be in the court than you deposit the amount, I will give. You deposit the amount, I will grant. You deposit entire. You deposit entire. If it is a special, if it is a private individual, I should have stated. When was the acquisition proceeding? 1993 LAC. Huh? You deposit, I will. No, you deposit entire. Issue emergent notice. 50% full. Huh? You serve copy. So you deposit full amount, I will grant a stay. Another 25% money. Nothing else. Nothing will happen. You deposit. See, you are not depositing some other money. It is their money. You are supposed to give it to them. No. If you succeed, you will get back. If you deposit, at least they will get it by the time. Next matter. Next matter. Yes, definitely that you are entitled. Third, and a counsel appealing for the petitioner undertakes to deposit so
subject to deposition.
So, yes. 8-4 ಇದೆಯಲ್ಲ. Yes, very well. That's true. Then full stop. Stay of order dated 23/11. Just a 23/11. What is it? Stay interim order. What is it? Stay of further proceedings. Stay of further proceedings in execution number 615 of 2006, pending before the second additional city civil and session judge and special judge. Second additional city civil session judge and a special judge, City Civil Court, Bangalore, subject to the petition's hearing, deposit the amount claimed in the execution petition dash 47 lakhs 0.
That is it. I have got money.
What is claimed? What is claimed in the petition? In the
4,70,814 rupees. 4,70,814. According to there are submitted.
See, go to page A, annexure A to the petition. 4 lakhs, huh?
Yes, madam.
4 lakhs, 4,70,814. Within 2 weeks from today, failing which the interim order shall automatically expire. Yes. Yes, sir. Amendment. I think issues have not been framed.
That is one thing. Why you have generally you have not highlighted? Kindly the amendment. will
See, in
be-
the issues anyway, the court will frame the issue.
That is secondary thing. Kindly the amendment which has been sought and the reason we.
Yes.
see, amendment is regarding a subsequent suit wherein it is been declared in his favor. That changes the cause of action automatically. Subsequent suit which was declared in 2017, this is the suit of 2015.
Go to annexure D.
Annexure
D.
D, madam. 54. Yes, madam. This is the amendment which is seeking.
Yes.
Amendment is almost 5 pages.
No.
That in that kind of, in that itself, page number 58 may be seen. 58 it may be for a moment.
Yes.
In the 58, para number 4B,
Yes, it is further submitted that.
it is further submitted that in schedule A of the plaint, this is the amendment is seeking to insert. In the plaint itself, he wants to insert this. At page number 7 of it has been wrongly taken as an extent of 1 acre 15 guntas instead of 2 acre 20 guntas. Out of total extent of 3 acre 30 guntas of land in so-and-so village, also in B schedule property at page number 12, extent shown as 1 acre 5 guntas.
Issue emergent notice when a counsel appearing for the petition is also permitted to serve copy to the counsel appearing for the.
No, I am not seeking further proceedings, sir. I am only seeking for stay of the impugned order. I am not taking anything.
Stay of impugned order dated so and so. Yes, sir. Suit for
After commencement of trial,
what they wanted to insert actually.
they wanted to insert relief for mandatory injunction. Your worship will find that at page number 30.
So suit for declaration and recovery of possession. Recovery of possession. Now they wanted to add one more para, mandatory injunction, any construction that you have made for demolition. No, that's correct.
Your worship, but it was made
Because
after
recovery of,
commencement of
they
trial.
sought for possession and they are also now amending the plaint for demolishing the construction that you have made in the suitable property.
Indeed, your worship, but it has been made after commencement of trial. your
Maybe
worship.
two. Maybe
And
two.
your worship, if I may show to your worship, the impugned order says that the trial is yet to commence.
Yes.
But the trial has actually commenced, your worship.
Yes.
Chief affidavit has been filed on
Very good.
17/12/2019. Documents have been marked by the plaintiff on 10/3/2020.
Yes.
And your worship, the application.
The said relief, the said relief is an ancillary to the main relief.
Your worship, my
That
guess
relief-
is that it changes the nature of the.
See, no, okay. See, they sought for recovery of possession from you. Recovery of possession from you means you constructed something else in this suit. They wanted to demolish. Huh? Yes, yes. That's why they sought for possession. Along with whatever the construction that you have put up, they sought for this.
Yes, your worship.
Yes,
So,
sir.
your worship, my humble submission is this, your worship, that this amendment ought not to have been brought on record after commencement of trial, unless
Yes,
the
yes.
plaintiff could have established due diligence, your worship.
Yes, correct.
And I have a few judgments also.
Yes, yes. Very good.
The first judgment, 2020, your worship. There is no finding, in para 8, your worship, there is no finding that the court is satisfied that in spite of due diligence, if the party could not introduce the amendment before commencement of the trial, the order of the trial judge is unsustainable. The High Court has not adhered to the above aspect of the
Yes.
matter. In view of the opposite, allow the appeal and set aside the order passed by the High Court is well done. And your worship, if your worship comes to para 10 of the second judgment, your worship. we
Para?
look at Page 7. para
Page
10.
7. Yes, sir.
Your worship, after they read out the proviso.
Proviso, it is
after the
couched in the
proviso is
mandatory
couched
form.
in a mandatory form. The court's jurisdiction to allow such an application is taken away unless the conditions preceded therefore are satisfied. This, it must come to a conclusion that in spite of due diligence, the parties could not have raised the matter before commencement.
Yes.
And your worship, again, the next judgment.
The suit filed for recovery of possession. Now they are seeking an amendment to demolish whatever it is a supplement. It supplement the main prayer.
My respectful submission is that this could have been done prior to commencement of trial, but they
Yes.
haven't done it even after complete. They've done it after 2 years after commencement of the trial.
Yes, sir.
That is my submission.
Very good.
Therefore, I request that an interim order be granted. Your Honor.
Yes. Third, this director, this writ petition. Is filed by the defendant number 1 to 4, please, sir, challenging the order dated 6/12/2021 passed by the senior civil judge and JMFC Somarpet in OS number 15 of 2019, allowing the application under Order 6 Rule 17 of CPC with cost. Brief facts for adjudication of this writ petition are that, the plaintiff has filed suit for declaration seeking, declaring that the plaintiff are owners of the suit schedule property, and also sought for direction to the defendants to deliver vacant possession of suit schedule property in favor of the plaintiff. Inter alia, order for inquiry under Order 20 Rule 12 of CPC and to direct and also sought for delivery of suit schedule property to the plaintiff. Full stop. The said suit was contested by the defendants by filing written statement. So issues have been framed. In the meanwhile, the plaintiff has filed the application on Order 6 Rule 17 of CPC, seeking addition of another prayer with regard to grant of mandatory injunction against the defendants to demolish the structures constructed by the defendants in the suit schedule property. The said application was resisted by the defendants. Listed. The trial court, after considering the material and record, by its order dated 6/12/2021, allowed the application with cost and permitted the plaintiff to amend the prayer. Full stop. The said impugned order, the said order dated 6/12/2021 is impugned in this petition. I have heard Sri Abhilash Lana counsel appearing for the petitioner, who contended that the trial court ought not to have accepted the application filed by the plaintiff seeking mandatory injunction, seeking incorporating the prayer to be made with regard to grant of mandatory injunction. He further contended that the plaintiff have not proved the due diligence as called out in Order 6 Rule 17 of CPC. Accordingly, sought for yes, sir? Due diligence accordingly is sought for interference of discord, since the matter is set down for the trial. Having heard the Lana counsel appearing for the petitioner, the relief sought for by the plaintiff is with regard to declaration with consequential relief of recovery of possession. The plaintiff has also sought for an inquiry on mean profits. Perusal of the prayer sought for by the petitioner, undisputably, the prayer number 2 is with regard to recovery of possession in the plaint, and in that view of the matter, I am of the view that the proposed amendment will not change the nature of the suit, and accordingly the trial court is justified in accepting the application filed by the plaintiff and Order 6, Rule 17, read with 151 of CPC. However, insofar as the arguments advanced by the learned counsel appearing for the petitioner with regard to due diligence, the trial court has noted in the impugned order that the proposed amendment is ancillary to the main prayer, and accordingly, in order to compensate the same, the said application was allowed with cost, and in that way of the matter, I do not find any merit in the writ petition. Accordingly, same is dismissed. Where is he? You should have to. Office memo. So it is their office memo. Previously, tomorrow, no. Tomorrow, just tomorrow, repeat. Just you should have bringing to. Ille bandral. See, just you show it to him. Just you show to him order sheet. How the solution they are entitled. It is a statutory.
This interest, that is already, that is not found in the letter. They have deposited 4 lakhs something, that is the amount to the sheet. Now we say come to the 50 lakhs, that is, we have filed the objection again, we filed the objection.
This is the memo. It is your note.
Not, these are their memo, not for the, I have to file this memo objection my lordship. Without considering my objection, what is the amount?
We will have it next week anyway. Anyway, we are having next week. Yes, no problem. Question? How matter? 2 weeks go to list on so on. Yes, ma'am. No, I stayed. I'm sailing with you. I'm sailing with you. ನಾನು ನಿಮ್ಮ ಪರವಾಗಿದ್ದೀನಿ ಮತ್ತೇನಕ್ಕೆ ಮಾತಾಡ್ತೀರಾ ಮತ್ತೆ ದಟ್ಸ್ ವಾಟ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಮತ್ತೆ ನೀವು ಮಾತಾಡಬೇಕಾಗಿಲ್ಲ ಮತ್ತೆ yes it will but so and so till next set of year. No, let they will deposit. You file it, let us give it. You no, next matter it will. You file it, sir. You file it on the next date of hearing. Nothing will happen. We'll get more interest for another 1 week. Nothing will happen. But no. 2 weeks date won't put. 24th. Nothing will happen. Sir, deposit madli. Avat you file it. Let us. Next matter ತಗೊಳ್ಳಿ. Yes, let us see. Let they will deposit. Even otherwise, let they will deposit whatever the amount. You file a memo of calculation. Let us we will see. You should have filed it in the not now. You should have filed it in the beginning itself. 25th you file it. Nothing will happen, sir. Nothing. ಇಲ್ಲ ಆಗಲ್ಲ ತೊಂದರೆ ಇಷ್ಟೇ 72 ಇಂದನೇ ಬಂದಿಲ್ಲ ಇನ್ನು ಅಟ್ಲೀಸ್ಟ್ ನಿಮಗೆ 5 ಲಕ್ಷ ಸಿಗ್ತಾ ಇದೆ ನೆಕ್ಸ್ಟ್ 25th ಕಾಲ್ ಆನ್ 25th ಕಾಲ್ ಆನ್ 25th ಬೇಡ ಕಾಲ್ ಆನ್ 25th ಬೇಡ 25th let it we have many matters on those days Yes, sir. ಇಲ್ಲ ಆಗಲ್ಲ. Sir, 24th itself is a short date, nothing to be worried. You file a memo. No, no. You file it, no problem. You file whatever the memo of calculation, it will be accepted on that day. So only 2 weeks that happened. Sir, you are appealing for a KDB, I don't want to say. Next matter. Nothing else. You file it in the registry. Sir, deferred is madly. You 55th, you file the memo of calculation. No, next matter. Yes, Mr. Yes, sir. No, nothing else. Yes, not 25th it will. Sir, many matters are there actually. Sir, one time alert, don't waste time, please. No. Sorry. What is missed? Nothing. Sir, you file it. Not correct, sir. Not correct, Mr. P. Chandrasekhar. Sir, 25th you file memo of calculation. You file it, it will be considered. Nothing but sir, 25th. Sir, we have every day I'm getting 870 memos. You can't imagine. Can I say one more sentence? So, say every day I'm having not more than 4.5 to 5 years. I have to read entire papers. Can I say? No, not correct. So every day 50 matters means, so at least minimum 20 matters I have to dispose. These are all CRPs. Not before maintenance. Mr. P.V. Chandrasekhar is not willing for report. Here this matter, this matter be posted before Honorable Chief Justice. Yes, next matter. Next matter. Sir, please don't. Please ask your seniors. Better simple. Yes, Mr. Raghunath. Yes, Mr. Raghunath. Yes, Mr. Raghunath. Yes, sir. Yes, sir. No, correct. So 20 will file it to be too better. Yes, sir.
On 5/7/2014.
What your challenge, sir? What your challenge?
Duty and penalty.
Annexure G.
Yes, imposing duty and penalty for the second time.
1 minute, sir. 1 minute. Yes, sir. Suit for?
Suit for specific performance.
Stamp Act. Suit for?
Specific performance of the agreement.
Yes.
On 5
What's the relevant provision in the Stamp Act?
Before going to that, the register of the trial court has already raised note saying that I have to pay duty and penalty of 85,500 and 29,800 on exhibit P1 and P2.
Yes, sir.
While the submission dated 16/2014.
Yes, sir.
I have deposited that amount.
Yes.
Subsequent to the order and the instance of the defendant who have filed an application under section 34 and 35 of contract, the court now directs me to pay a duty and penalty once again.
Yes.
But this order is understandable.
Yes.
I can't be penalized twice in this application.
Let's go to findings. Finding recorded.
Kindly take increase 45.
52 go to.
Please.
52. I have gone through the Article 5E11 of the Karnataka Stamp. 52 page.
Yes, sir. I have gone through the order sheet. Yes, I have gone through
Article 5.
Article 5E1 L1.
Yes, sir.
Karnataka Stamp Act that exhibit and exhibit P1.
Yes.
As per 5E1
Yes.
Stamp Act, the plaintiff has to pay stamp duty of exhibit P1 at 7.5%. So the same consideration of exhibit P1 is 35 lakhs. Into 7.5% will be 2,52,500. The
Yes, sir.
plaintiff has already paid 85,500. After deduction of 85,500, plaintiff has to pay 1,77,000 and duty on exhibit P1 as per Article 5E.
I Correct.
far as exhibit P2 is concerned, plaintiff has to pay 3,000 as legal penalty. Plaintiff has already paid 29,800 on exhibit P2. Thus, the plaintiff has paid excess amount of 26,800 on exhibit P2. In the interest of justice, this court is of the opinion that plaintiff is entitled to deduct excess amount of 26,800 and the same to be adjusted in stamp duty of 1,77,000 after deducting 26,800 in 1,77,000. The plaintiff has to pay defensive stamp duty of 1,50,200 on exhibit P1. Thus, the plaintiff has to pay stamp duty of 1,50,200 on exhibit P1.
10-time penalty which amounts to so much. Correct.
My submission is that when the registry on production of the document has made a note saying that I am liable to pay only 85,000
Yes.
and 29,800. I haven't complied to say my deposit. The court wouldn't have passed such an order.
So that was done by the registry.
Yes, Lord.
This is by the court.
Lord, court on submission has accepted. Court
Yes,
directed
true.
me to deposit.
Yes, yes,
Lord, court on that day itself had to have said
Yes.
that I should have paid duty and penalty at the rate calculated to the court.
yes.
But I will not say so at that point of time, what the court at the second instance and the instance of respondent.
Thereafter, at the instance of the defendant number 2,
Yes,
see, while filing the returns, while filing the suit, the registry has calculated.
at the name of evidence.
Yes, no, while filing the suit, the stamp duty was calculated by the registry.
Yes, Lord.
That was paid.
That was me.
That was paid. Thereafter, the application was filed by the plaintiff, by the defendant
Yes,
under section 34 and 35 of the Stamp Act. Then, see, the said document is not registered and not paid the stamp duty.
that is what the error was. At the most, the court could have said, if there is any duplicate, the court could have impounded the document and sent it to registrar for complaint. But they couldn't have.
At any stage, it can be done.
But it can't impose twice on people. This is nothing but double your part.
See, no. That you have to pay the, no, not double. Already you paid some duty, sir.
No, as per the registry's calculation.
See, registered calculation you paid, no doubt. Thereafter, the court has made a calculation at the instance of the defendant's application.
This is the error which the court.
Not error. See, they raise an objection.
But every defendant raises an objection.
That's why the court has calculated in terms of what is it?
33 and 34.
Yes,
34 and 35.
in terms of the section Article 5E.
Certainly.
Now I have arrived at a conclusion that this much of, that is, take for an example, 1,77,000 has to be paid on Exhibit P1. There are two documents. Insofar as Exhibit P2 is concerned, the court has arrived at a conclusion that 1,50,000 with 10 times penalty because it's an unregistered document.
This order, the court could have passed immediately when the registry had made a submission and order sheet. The court had not made such an order.
No, even at the later stage also it can.
But there can't be two stamp duties.
So not stamp duty. You paid, that was calculated.
Court accepted it.
Yes, see, at the time of filing it was accepted.
Not at the time of filing,
No.
at the time of reading evidence.
Yes, very well.
Exhibit
Now,
C,
and yes,
when I entered the witness box,
Yes.
exhibit P1 and P2 were marked.
Mark, yes,
Subsequently, court notes that there is a deficient stamp
correct.
duty.
Because they are the unregistered documents.
It is not necessary to be registered now. You understand? The Lord is aware that it will not be registered. Not it is only to look into whether proper stamp duty is.
For admissibility of the document,
Yes.
yes,
Now the court directs the registry to calculate.
yes.
The registry calculates.
Hmm.
The court accepts it. I have been directed to pay the duty and the stamp duty and penalty as calculated. to the registry. Having done so, that there ends the matter.
Need not be. Need not, but any time, at any point of time during the pendency, this issue can be raised. Not to adjudication.
This is nothing but settlement.
No. See, so that's the way. At the time of filing the suit, you paid some amount. As
As directed by the registry, not some amount.
yes, as directed by the registry.
Yes.
Registry is different from court.
No.
Registry say you need not pay. Take for an example.
No.
Registry may say that you need not pay at all. Not even 1 rupee.
But immediately court should have directed.
That they have done now.
Not now. From 2017.
Yes.
Till 2022 court keeps quiet.
Yes. Can you say that during thereafter they cannot at the later stage also it cannot be raised?
Not having adjudication. My point is there is already an adjudication. Court has accepted
Not
it.
adjudication. Adjudication means deciding.
Yes, sir.
The court has
There is a
decided
direct
whatever the stamp duty that you have paid was calculated by the registry, that was accepted at the time of filing the suit.
Not filing the suit, at the time of giving evidence.
Yes, even otherwise.
Once
Thereafter, the court has come to a conclusion at the instance of the application filed by the defendant under section 34 and 35, recalculated the same.
How can it be sufficient?
It can. Sorry, this is as per section 5E.
No, they cannot. My sufficient is, and defendant.
You say it cannot be done. Can you
The reason may not be the registry raises the note. Court accepts it. The moment courts accept it, there is a direct duty to deposit. I have deposited. The duty penalty chapter is closed.
No.
Kindly read 33 and 34.
Yes, sir.
How it can be done? Examination and impounding of instrument. Every person by law, section 33, or consent of parties authority to receive revenge, and every person in charge of public office, except an
See,
officer.
this was when the suit was posted for a cross-examination to PW1. The defendant number 2 has filed an application for impounding.
I concede not.
Yes.
When not, my point is not when the court itself has said in the first instance deposit, there is stamp payment of stamp duty.
Where is the law on the point?
It has to be implied or not.
No.
There is no decision.
That's why I said,
My lord has to lay down the law.
no, nothing else. I don't want to lay down without contrary to the Stamp Act.
My lord feels that I do my research and submit.
Very well. That is better.
Unleash the
That is better. When do you want?
next week any day.
Any day of your choice. Any day of your choice.
I shall apply the law.
Any day of your choice.
22nd or 23rd.
Yavat. Yes, any day.
Please.
Very good. Yes, sir.
Suit for partition for the respondent number. After doing the petitioner came to know the registered document.
In fact, very two cases out of Bangalore had appeared. That too in Davangere actually. Just are seeing the Learned Council appearing for the defendants here. Go to 28th page. I don't know whether go to order sheet page 27. Go. Order date 17/7/2014 is there. Left side, right side, down. Mr. So and so advocate file wakalat for this. She ESI advocate file wakalat for. I don't know. Some two suits that too in Davangere. But parties I cannot remember. Okay, let us you go on with me. I think this matter I have not verified also. Actually, not appear. So it's a suit for partition that I have not. That's a specific purpose. Very well. Yes, sir. What you have challenged? Amendment of the return statement. Yes, sir. Where is the impugned order? Where is the impugned order? Yes, 32, please read. Point number 1. admission given in para 11 and 13 of the written statement. Please read it. Please read it. The written statement is stated. Para 11. ಮೂರನೇ ಪ್ರತಿವಾದಿ ಹೇಳುವುದೇನೆಂದರೆ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತಾಗಿದ್ದು ಸದರಿ ಸ್ವತ್ತುಗಳು ಇಸ್ಸಿಯನ್ನು ಕೇಳಲು ಬಾಧಸ್ಥಳ ಅಲ್ಲ, ಅಂದ್ರೆ ಹಾಫ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಕೇಳಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ಹೇಳಿ, ಮುಂದೆ ಹೋಗಿ. ವಾದಿಯು ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಹಾಗಾದ್ರೆ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತು ಅಂತ ಮೇಲೆ ಹೇಳಿದಾರಲ್ಲ ಪ್ಯಾರಾ 11 ಅಲ್ಲಿ ಅದಕ್ಕೆ ಡಿಫ್ರೆಂಟ್ ಆಗುತ್ತೆ. Maybe yes. Of course, we have admitted in the evidence, and also you have stated in the earlier written statement also. It will change the nature of it. Just you tell me. You yourself to tell me. Definitely it will change. Earlier stated that ಮೂರನೇ ಪ್ರತಿವಾದಿ ಹೇಳಿದ ದಾವಾ ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ವಾದಿಯರ 1ನೇ 5ರಿಂದ ಪ್ರತಿವಾದಿಗಳ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತಾಗಿದ್ದು. ನೀವೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ರಿ ಇದು ಆನ್ಸೆಸ್ಟರ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ. ನೋ ಐ ರೆಡ್ ನೋ ಸರ್, ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಇಟ್. ತಗೊಳ್ಳಿ, ಐ ಥಿಂಕ್ ಇಟ್ ವಿಲ್ ಚೇಂಜ್ ದ ನೇಚರ್. ಡೆಫಿನೆಟ್ಲಿ ಇಟ್ ವಿಲ್ ಚೇಂಜಸ್. ಯು ಯುವರ್ ಸೆಲ್ಫ್ ಇಸ್ ನೌ this writ petition is filed by the please read by the defendant number 2 to 5 in OS number 357 of 2014 on the file of the additional civil judge Davanagere, challenging the order dated 17/9/21 on IA number 13 filed by the defendant number 3 under order 6 rule 17 read with section 151 of CPC. Plaintiff has filed a suit for partition and possession of in respect of the suit schedule property. The defendant entered appearance and filed detailed written statement denying the averments made in the plaint. When the case was set down for further cross-examination of the DW1, the defendant number 3 has filed IA number 13 under order 6 rule 17 of CPC, seeking permission to amend the written statement. And the said application was resisted by the plaintiff. The trial court, after considering the material and record, by its order dated 17/9/21, rejected the application and being agreed by the same, defendant number 3 has filed this writ petition. I've heard Sri Hiremat Maheshaya Rudraya and a counsel appearing for the petitioner, who contended that the proposed amendment to the written statement is will not change the nature of the suit. He further contended that the proposed amendment is required to safeguard the interest of the defendants, since the suit is one for partition and separate possession in respect of the suicidal property. And accordingly, he sought for interference of this court. In the light of the submission made by the Lana Council appearing for the petitioner, I have carefully considered the proposed amendment sought in the application at Annexure C to the writ petition. Perusal of the proposed amendment to the written statement and the amendments made in para 11 and 13 of the written statement are distinct, and therefore the impugned order passed by the trial court rejecting the application is just and proper, since in the event the proposed amendment is accepted, same would cause irreparable loss to the plaintiff, and on the other hand, the proposed amendment would withdraw certain admissions made in the written statement, particularly at para 11 and 13 of the 13, and therefore I do not find any merit in the writ petition. Accordingly, same is rejected. Yes. Issue emergent notice. Lana Council appearing for the petition is also permitted to serve copy to the Lana Council. When you file the written statement.
I filed it on 15/12/2021. I actually attempted to file it on 16/11/2021, but because my written statement was not accompanied with a statement of truth, the learning trial court asked me to file on the next date, so I filed it later. And your worship, on 26/5/2021.
What is the long point in so far as commercial court is concerned? I think after this, you refer to some judgment.
Yes, my lord. In fact, even on
earlier it was directory.
Now, my lord, they said that given the period that could be controlled, the additional period of 90 days, so 30 plus 90, 120 days is what CPC has amended for the Commercial Court Act provides. That additional 90 days also the limitation order applies to is what the Supreme Court has said.
Where is yes.
Judgment. My lordship, can you consider this? My lord, I have actually even placed a judgment of Justice Nagartha, which is part of this.
No, just go to this. Go to order.
Yes, sir.
Whether this relaxation was given for the reason that SOP was enforced or insofar as the provision under the commercial code is concerned.
Because SOP was enforced.
That's why. In the SOP, insofar as the Supreme Court itself has relaxed the limitation.
And therefore, because it is covered and seeking an interim order, your lordship, what happens is that in the commercial court, after the parties file their pleadings, your lordship, they have to admit and deny documents.
1 minute. Issue emergent notice. Stay of further proceedings in commercial OS number 66 of 2021 on the file of the so and so Mysore till next date of hearing. This first, then a counsel appearing for the petitioner is also permitted to serve copy to the then a counsel representing the respondents before the trial court. List this matter 15 days put on. List on. I think last week also one more judgment had come. Not Madras judgment that you refer to, it is affirmed by the Supreme Court. Last week, it may be enlarged. So following the Salem Advocates Association judgment. Now it is say that it's not mandatory, it is directory. Very. 28, sir.
These documents are the copies of the documents which were placed before the trial court by plaintiff.
Who appears to know?
Appears to be served on the other side.
You are for the?
For the respondent.
Respondent. Third, no representation on behalf of the petitioner. None a counsel appearing for the petitioner filed certain file copies of the documents which have been placed before the trial court by the plaintiff, and the same is accepted. Come on, list this matter next week.
Last week of
March. Better 2 weeks. Next week is not represented. Next week let us see. Since he is not represented. Yes.
Serial number 28.
28.
Yes, I am for petitioners. Kindly pass over, my lord.
No.
Senior engaged in other court, my lord. There is an urgency in matter, my lord. Please, my lord.
You argue the matter, I think.
My lord, senior.
Next week it will be taken up. One day we have filed certain documents.
In view of the impugnator, my lord, construction was stopped. Please, my lord.
Yes,
urgency, please, 2:30, my lord. Please, my lord. 2:30.
2:30 we have some other matters actually.
Just pass over, my lord. I will inform the senior, my lord. Please, my lord.
No. 2:30 I have a detailed matter. I think take it up next week.
My lord, please, my lord. There is an urgency, my lord. In view of the impugnator, construction was stopped.
List on Tuesday. List on Tuesday.
Great.
Yes, 15.
Yes, 15.
Yes, Raghavendra K. Yes.
I am for the petitioner, my lord. Serial number 30. Serial number 30, my lord.
Yes. Just a minute. 29, sir. Sridhar Murthy.
Sorry, my lord.
Yes. Next matter will be yours, sir. What your challenge? Order 26 rule. Yes. Suit for declaration. At what stage the application was filed? At what stage this application was filed? At the stage of 20. Yes. Why the appointment of the commissioner is required?
I am for the respondent, defendants in the trial court.
Defendant before a trial court. Application has been allowed. Yes.
And
why the appointment of the commissioner was sought by the plaintiff?
Plaintiff, separate cases that he is in possession of the instituted B property.
Go to page 19, para 10.
Para 10.
Please read.
It is very much necessary to appoint commissioner for local inspection to ascertain the encroachment of this 5 members.
In order to ascertain the encroachment.
No. This observation is wrong. Reason, this is specific case of the plaintiff.
You go to application. Otherwise, you go to his application under 26. You go to application.
Application Act. At page number 82.
Correct. Annexure G.
And at page number 85, 85 second paragraph.
To demarcate the land dash guntas out of the 23 guntas of the property purchased by the father of the plaintiff. See, for demarcation of a certain area. Yes.
But this purchase of 23 guntas by the father of the plaintiff is of year 1936.
Yes, because he said that 5 guntas of the property fallen to the share of my father through Palupatti.
No, there is no documentary evidence. As per his own pleadings.
That is what is stated in the affidavit.
Yes, that
Of
is
Palupatti.
stated, but
And remaining 9 guntas of property divided in between me and my brothers. Extent of each member is 2 guntas. And again, I have purchased the 2.5 guntas through registered sale deed.
from his brother.
Yes, therefore, in order to ascertain the boundary, the appointment of the commissioner was required.
But the observation what the trial court has made is wrong for me. You want to go to the page 85.
85. 85 with the affidavit.
Affidavit. At second paragraph. Lot 70. 5 guntas of land belonging to my family. It is illegally on the strength of said RTC extracts and the extracts. The defendants are come to interpret my peaceful question in respect of these
Property, yes.
hence I have paid the suit for seeking
Declaration, yes.
In respect of suit schedule.
Because any amount of the evidence that you may adduce, that cannot determine effectively the suit.
1936 ನಲ್ಲಿ ಸೇಲ್ ಆಗಿದೆ 1963 ನಲ್ಲಿ ಫಾದರ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಸೋಲ್ಡ್
That is insofar as how the demarcation of insofar as the demarcation is concerned.
ಡಾಕ್ಯುಮೆಂಟ್ ಅವರು ಏನು ಹೇಳ್ತಿದೆ ಅಂತ 1936 ನಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ ಫಾದರ್ ಸೋಲ್ಡ್ 9 guntas.
Yes, go to para 10 of the impugned order. Because this is a suit for declaration.
But at para 1 order is this.
The plaintiff in his application contended that
There is no contention of this in his entire affidavit. The specific case of the plaintiff is that he is in possession of scheduled property.
1 minute. No, just you go to the application where it say that it's encroach.
He has not stated anywhere that defendants are encroached. This specific case is when he is in possession of the scheduled property. Then in page number 37, plaintiff.
Say that. Just now we read it. No, the para 85 will be. Page 85. That is the later para. Page 85. Affidavit. The grandfather of the defendants purchased property in bearing so and so through registered sale deed 1936. Except this property, there is no remaining property belonging to the defendants in the very same survey number. Correct, Allah? But the defendants, in collusion with the revenue authorities, have created a document to an extent of 33 guntas against the 28 guntas, including the 5 guntas of the land belonging to my family. That means you have encroached the 5 guntas of land belonging to the family. No. Maybe it is no according to you. This is a averment made in the affidavit. That has to be ascertained. Allah, that has to be ascertained. Not ascertained. It cannot be ascertained. This document, this has to be, the 5 guntas has to be ascertained only by way of the commissioner, that is ADL.
ADL already made some DDL opinion ಹಾಕಿದ್ದಾರೆ. ಅದು observation ಇದೆ. That observation is that annexure L.
Yes. Because since because you are denying the existence of the property in the return statement.
1963 ನಲ್ಲಿ ಅವ್ರ plaintiff's father sale ಮಾಡಿದ್ದಾರೆ. ಆ sale deed annexure L.
That's why the court say that you already denied.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ sale deed ನಲ್ಲಿ ಅವರೇ
You denied the existence of the property.
existence ಅಲ್ಲ ಸ್ವಾಮಿ ನಾನು ಹೇಳ್ತಿರೋದು. ಅದು
Allah, you means the defendant.
page number 90 ನೋಡಿ sale deed.
9?
90.
So you go to return statement.
ನಾವು ನಮ್ಮ position ಇದೆ ಅಂತ ಹೇಳ್ತೀವಿ.
That's what.
ಅಲ್ಲಲ್ಲ.
You are saying that you are in possession of this land. According to plaintiff.
ನಮ್ಮ possession ಗೆ RTC
Yes.
ಇದೆ. ಇಲ್ಲಿ ಅವ್ರದ್ದು sale deed ಇದೆ ಸ್ವಾಮಿ. page number 90.
Yes. That's why on a schedule A and B property has to be demarcated.
ಅಲ್ಲ page number 90 ನೋಡಿದ್ರೆ ಸ್ವಾಮಿ. Last 2 lines. You type out copy ಹಾಕಿದೆ ಸ್ವಾಮಿ. Last 2 lines. The entire sale deed. ಅದರಲ್ಲಿ schedule of page number 90 type out ಹಾಕಿದೆ.
Yes, sir.
ಈ ಮಧ್ಯೆ ಇರುವ ಸರ್ವೆ 4ನೇ 25 ಗುಂಟೆ ಆಕಾರ 50 ಪೈಸೆಗಳ ಕೃಷಿ ಒಂದು ಈ ಜಮೀನನ್ನು ಬಿಟ್ಟು ಪಶ್ಚಿಮ ದಿಕ್ಕಿಗೆ 9 ಗುಂಟೆ ಜಮೀನನ್ನು ಮೇಲ್ಕಂಡ 1,000 ರೂಪಾಯಿ ಶುಲ್ಕ 18 ಗುಂಟೆ ಜಮೀನು ಅವರೇ ಪ್ರಾಪರ್ಟಿ. The survey number 4 is quoted in year 1938.
Yes, sir.
1938 ನಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ ಕೋಡಾಗಿ plaintiff's possession or defendant possession has been recorded. Based on that, the plaintiff's father has not challenged anywhere from the year 1938. The defendant and plaintiff's family is in possession of respective property from 1938 itself.
Yes.
Plaintiff's father sold 9 guntas out of 18 guntas. This one record is stating that he is having only 18 guntas in survey number 4.
That has to be demarcated. That whatever now you say, whatever the demarcation that you say, that is denied by them.
ಅಲ್ಲ ಅವರು ಸಹ ಸೈನ್ ಹಾಕಿಲ್ಲ 1995
Sign hakila means that they are not accepted. That's why the court has allowed the application.
ಪ್ಲಸ್ ಎಕ್ಸಿಬಿಟ್ ಅನೇಷನ್ ಕೇನಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿದೆ ಅದು
Told him. This petition is filed by the defendants 1 to 6, 1 to 6, challenging the order dated 9/1/2022, allowing the IA number 14 filed by the plaintiff and order 26 rule 9 of read with section 151 of CPC. Full stop. The plaintiff has filed a suit for declaration, declaring that the grandfather of the plaintiff is the absolute owner in possession of the A schedule property as per the sale deed dated 19/9/1936, and also sought for the declaration with regard to the suit B schedule property. No, inter alia, one nimsha, one paragraph ಬಂದ್ಬಿಡ್ತೀನಿ. Inter alia seeking consequential relief of permanent injunction. Yes, 100. Yes, sir.
ಆದರೆ 1938ರ ಇಸ್ಸಾ ಸರ್ವೆ ಕಾಲದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 4ರಲ್ಲಿ ಇಸ್ಸಾ ನಂಬರ್ 6 ಇಸ್ಸಾ
So this is the revenue record. See, revenue record will not confer title.
ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಕೊಂಡು DDL
DDLR ಅಂದ್ರೆ revenue authority. See, revenue authority cannot confer title.
ಟೈಟಲ್ ಅಲ್ಲ ಸ್ವಾಮಿ,
It is a suit for declaration.
ಹೌದು
ಮತ್ತೆ
ಅವರು
suit for a declaration.
ಇದು ಅಪೀಲ್ ಫೈಲ್ ವಿತ್ ಪ್ಲೇಂಟ್
Correct.
ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ರೆ 38
Told him.
ಒಂದು ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
Full stop. The full stop. In the said suit, the plaintiff has filed application in IA number 14 and order 26 rule 9 to appoint the ADLR Madhu as court commissioner to measure and demarcate the suit A schedule property in terms of the sale deed dated 19/9/1936, and also to demarcate the suit B schedule property as suit B property as part and parcel of the A schedule property. The said application was resisted by the defendants. During the interregnum period, when the suit for posted for arguments, plaintiff has filed an application seeking appointment of the commissioner, stating that the defendant has encroached 5 guntas of the property belonging to the plaintiff in terms of the sale deed dated 19/9/1936, accordingly sought for appointment of the commission. No, contended. The said application was resisted by the defendants and the trial court having considered the rival submissions by order dated 19/1/22, 19/1/2022 allowed the IA number 14 and feeling aggrieved by the same, defendant has preferred this writ petition. I heard Mr. So-and-so and a counsel appealing for the petitioner, who contended that the trial court ought to have dismissed the application on the ground that the suit has been filed by the plaintiff with regard to the declaration of the sale deed dated 19/9/1936 and no declaration be made insofar as a dead person. Inter alia, the Lana counsel appearing for the plaintiff, defendant, Lana counsel appearing for the defendant / petitioners hearing further contended that the trial court fails to consider the fact that the plaintiff has sold 9 guntas. Plaintiff, yes? Father of the plaintiff. Father of the plaintiff has sold 9 guntas of the land in the schedule of the sale deed dated 25 schedule as per the schedule 2 sale deed dated 25/11/1963, and therefore the trial court ought not to have accepted the application filed by the plaintiff seeking appointment of the commissioner. In the light of the submission made by the Lana counsel appearing for the petitioner, I have carefully considered I have carefully examined the writ papers which would substantiate the fact that the plaintiff has raised a contention that the defendant has encroached 5 guntas of the property belonging to the plaintiff, and same was denied. However, the defendant had taken a stand in the written statement with regard to the existence of the property itself, and in that view of the matter, trial court is justified in allowing the IA number 14 filed by the plaintiff, and accordingly I do not find any merit in the writ petition. Accordingly, same is dismissed.
For the petitioners in this case, my lord.
Yes, sir.
The petitioner number 1 herein has filed a suit in OS number 137 of 2003 for the relief of partition.
Who has filed, sir? Who has filed?
The petitioner number 1 herein is my lord.
Yes, sir.
He has filed a suit for partition.
Partition.
Partition
Yes.
In OS number 137 of 2003.
Yes,
that
sir.
is at annexure B, my lord, page number 18. Against the respondents, my lord. That suit for partition came to be decreed by the order dated 31 August 2012, my lord.
Yes.
In that judgment, my lord, kindly come to page number 30, my lord.
30.
30, my lord. Page number 30.
Yes.
That is the paragraph last but fifth line, my lord. Affirmative above, my lord.
So 1/3 share was given to
1/5, my lord. 1/5. Above that, my lord. Above that line, my lord. I may be permitted to read that line, my lord. Page number 30.
Yes, 1/5 share in all the social properties.
Above that line, madam, I may be permitted to read above that line, madam.
Yes.
But as observed above.
Page number?
The page number 30, my lord. Page number 30.
Yes, 30. Yes.
That above affirmative, my lord. Hence the
said observed above, the sale is not made
as
for
observed
legal
above, the said sale is not made for legal necessity. Yes, the said alienation is not binding
on the sale
of the plaintiff. The plaintiff is entitled for 1/5 share in the social property, since the plaintiff is entitled for partition and separate possession. Consequently, the suit of the plaintiff came to be declared, my lord.
Yes, sir.
Against that order, my lord, the respondent number 1 herein as preferred regular appeal before the Honorable Principal Senior Civil Judge Kolar, my lord.
Yes, sir.
That came to be dismissed. That came to be dismissed by the order dated 8th December 2014, my lord. That is Annexure C.
This order judgment and decree of the trial court was confirmed.
Okay, was confirmed, my lord.
Yes.
In that judgment, my lord, the learned senior civil judge was made one observation that is available at page number 56, my lord. Page number 56.
Yes, sir.
That is, my lord, in the same paragraph, my lord, 5 lines above, my lord, that I may be permitted to read that.
Yes, sir.
In the event the defendant number 4 claims any such equity, the court in the final decree proceedings may consider his request for allotment of the property purchased by him to the share of the defendant number 1 by working out equity jurisdiction.
Equity jurisdiction. Yes,
jurisdiction, my lord. In that, against that, my lord, the petitioner number 1 herein as preferred RSA, that is also dismissed, and that is confirmed the judgment, my lord. That I have not produced, that copy I have not produced.
So RSA was RSA number?
Dismissed. RSA number 1712 of 2015, my lord.
Just a minute. RSA number?
1712, my lord. Of 2015, my lord. So 1721. Sorry, my lord. 1721, my lord. RSA number 1721 of 2015.
1721 of 2015.
15. That came to be dismissed, my lord.
So that means the 1/5 share was
confirmed. Confirmed, my lord.
Yes, sir.
Was confirmed. After this, my lord, the father of the petitioners, father of all the petitioners herein, who is R. Nanjundagowda, he has filed a FDP proceedings. He has initiated a FDP proceedings.
Yes, correct.
Before the trial court, my lord.
Yes, sir.
In that FDP, during the pendency of that FDP proceedings, the Nanjundagowda was died, my lord.
Yes, sir.
After his demise, my lord, the respondent number 1 herein, even his sale deeds have ordered that not binding, my lord. Even though he has filed a application under Order 1 Rule 10 Clause 2, that is for transpose as a petitioner in the FDP proceedings.
Correct. He wanted to transpose.
He is not the family member of the petitioners, my lord. He is only claiming only the share which is allotted to the first defendant.
Correct.
That is the father of the petitioners, my lord.
Yes, sir.
Even he can claim his equity as a respondent, my lord. He is the party to the FDP proceedings. He is the respondent number 4 in the FDP proceedings, my lord.
Correct, sir.
The application whichever filed by the respondent number 1 herein,
the plaintiff, the original plaintiff Nanjundagowda is the vendor of the D4.
No, my lord. No. Munsami Gowda, defendant number 1. Who is the defendant number 1 in the OS proceedings? Defendant number 1 in the OS proceedings, my lord. R. Nanjundagowda. That is Annexure B.
Yes.
Not plaintiff.
He is the plaintiff.
No, my lord. He is the defendant number 1, my lord. R. Nanjundagowda. That is page number 18. May kindly come to page number 18.
18 alla one.
Cast title.
Yes, sir.
Defendant number 1 in that 18 cast title. Defendant
Yes.
number 1 R. Nanjundegowda.
D4
D4 purchased the himself as a
property from
petitioner.
defendant number 1. Yes.
He purchased the property that came to be, that sale deed came to be not binding on the plaintiff share as well as others share also, my lord.
Yes. Now he wanted to transpose as a petitioner.
Petitioner, my lord. Even he is not the family member of the petitioner's family, my lord. Even if he wants to claim the share, as far as the observations made by the learned senior civil judge, my lord, he can claim as a respondent number 4 also, my lord. The petitioners are the legal heirs of the deceased father Nanjundegowda, my lord.
That is only an observation made by the first appellate court. However, the first appellate court confirm the order passed by the judgment and decree in OS.
OS, my lord.
Share is given to you.
Given to me, my lord. Then my question before this honorable court, my lord, as per the provisions under Order 1 Rule 10 Clause 2, as far as the provisions under Order 23 Rules 2 also, he cannot transpose as a petitioner, my lord.
I know. The provision stated is different actually.
No, not only provision, my lord, he can claim as a respondent number 4, my lord.
Yes.
Whatever equity has been observed by the trial court, my lord, he can claim as a respondent number 4.
But his vendor has died now.
No, he has died, my lord. Even though he has died, he is the party before the FDB proceedings, my lord. He is the party. As a respondent number 4, he can claim. The petitioners herein, they are the legal heirs. They are to come as a petitioners before in the FDB proceedings, my lord. He can't come as a petitioner. That is my object before this honorable court, my lord.
Issue emergent notice.
And also, my lord, tomorrow matter is there, my lord. They are filing the amended petition also.
Counsel appealing for a petition is permitted to serve.
My lord, my submission, my lord.
Counsel representative.
My lord, one submission, my lord. No, one submission, my lord. If they file the amended petition, everything means
serve it.
again
that will. Copy and move it
I will tomorrow itself. I will serve the copy, my lord. But till the next date of hearing, my lord. No, till the next date of hearing, at least, my lord, because I have made out a prima facie case, my lord.
Application.
No, no, my lord. At least, my lord, one submission. Impugned order may be stayed, my lord. At least proceedings can be go. Impugned order, my lord. Proceedings can be.
We will see. We will see what will happen.
No, my lord. Impugned order. Otherwise, they will proceed with the matter, my lord. They will file.
Yes, Jagdish Mandargi, sir.
Yes, my lord. This is the plaintiff's writ petition, my lord. You filed an application under Order 6 to 17 for amendment of plaint. That has been rejected. He sought for amendment of the plaint, my lord, incorporating the relief.
So evidence has been concluded.
Yes, ma'am.
And the court has conclusion that it is not necessary to decide the real question in the.
No, it is very much necessary because, my lord, there is a larger relief which I am entitled to now, because the property which I have sought for easementary right is in my own property.
Yes, he wanted to. That is you are introducing a new cause of action actually.
No, my lord, it is the same continuation.
No,
only subsequent to the filing of the suit, my lord. You lordship may kindly for a moment see the.
Go to the application. Order 6 Rule 17.
Yes, sir. Yes, I will. It is in page 32, my lord. Annexure D.
Yes, Annexure D. Yes, sir.
Yes, so amendment sought for first to delete the words for hence for such other consequential leave.
The deletion of so and so.
Yes, sir. To add second one, my lord. Second one, to add one para before the para 12 as under. The plaintiff humbly submits that the preparation of the sketch as per the holding of 8 guntas, which is not in dispute, my lord. The defendant's father has sold the said property to me. By him, by the survey authorities, was not within his knowledge. And he was under the impression that Podi has not taken place. Hence, the plaintiff claimed easementary right. It is a.
Now you are claiming easementary right.
That portion.
By way of the amendment.
Yes, ma'am.
That cannot be done. That will change in nature. Definitely, it will change.
No, but the portion of
by way of by way of the application. Now you are seeking easementary right.
No, I have not given up.
Yes.
The portion
But
of
you
the
not given up,
landlord
but you are
about
not
which-
sought for in the beginning. Now you are making
No,
plaintiff
that-
claim easement right over mutual property.
Yes, which was not in my knowledge. But
Yes,
that portion of the
yes.
land, I was under
No,
the
sir, it will
impression
definitely it will change the nature of this.
No, I was under the impression, that is what
Maybe you are under the impression, but it will change definitely.
when I came to know, during the pendency, I came to know about this.
Yes, sir, yes, sir, yes.
Because the courts have taken the view, if he is entitled for a larger relief
Yes,
than the
sir.
one which that can be added.
Yes, sir. No, sir.
It is the
It will
Patna High
change.
Court, 1973 Patna,
Yes, sir.
page 153 Malad AR is very clear on the point. When I am
Yes.
entitled for a larger relief,
Yes, sir.
I am entitled for larger relief, Malad, and it
That
will
you
also.
no, that you cannot enlarge the scope of the plaint, whatever the prayer that you made in plaint
No, you last time,
by way of amendment.
No, only thing is now there is no further evidence is required. Only I
Yes.
sought for easementary right under the impression that this portion is adjoining to my purchased property.
That
Now
was
I
your
came to
impression
know.
that you are in the wrong impression. That's all.
Malad,
That cannot be. I think it will. I think
no, very much because
it will change the
unnecessary.
nature of the suit. Definitely, it will change the
It will
nature.
curtail unnecessary further
Will
litigation.
Nothing will happen.
And
Nothing will happen, sir. Nothing will happen. This writ petition is filed by the plaintiff, challenging the order dated 23rd September 2021 in OS number 97 of 2015 on the file of the Court of Principal Civil Judge and JMFC at Malur, rejecting the IA number 10 filed under Order 6, Rule 17 of CPC. The plaintiff has filed a suit for declaration, and the said suit was plaintiff has filed a suit for declaration, and the said suit was contested by the defendant by filing written statement. When the case was posted for cross-examination of the DW1, the plaintiff has filed an application under Order 6, Rule 17, seeking deletion of certain paras and also sought for addition of the para number 2 in the plaint.
12, para 12.
Para 12, yes. As per Annexure D to the writ petition. The said application was resisted by the defendant. The trial court, after considering the material record by order dated 23rd September 2021, rejected the said application, and being agreed by the same, plaintiff has preferred this writ petition. Sri Jagdish Mundargi, on a counsel appearing for the petitioner, invited the attention of the court to the proposed amendment to be made in the plaint as per Annexure D, and submitted that though the suit is filed for the declaratory relief, however, in terms of the impugned application, plaintiff is seeking larger relief from the court, and the said aspect of the matter was not considered by the trial court. Accordingly, he sought for interference of this court. In the light of the submission made by the Lana counsel appearing for the petitioner, I have carefully considered the proposed amendment sought for in the application referred to at Annexure D. Full stop. Undisputably, the suit is filed for declaration, and by virtue of this proposed amendment, plaintiff intend to introduce the new cause of action seeking easementary rights insofar as the scheduled property is concerned, and
Schedule B property.
Schedule B property, which cannot be accepted as the same would change the nature of the suit filed by the plaintiff at earlier point of time. And in that way of the matter, I find that the trial court is justified in rejecting the said application. Full stop. It is also made clear that while rejecting the application, the trial court has observed that the said proposed amendment is not required to decide the real question in controversy between the parties. And therefore, inter alia, the said application is filed at the time of the cross-examination of the DW1, and therefore, I do not find any merit in the petition. Accordingly, same is dismissed. Yes. Yes, sir. You filed this. You filed the. You are for the defendant. Order 6 Rule 11. Order 6 Rule 11 rejection. Yes.
11D,
Yes.
There is an agreement between the defendant and the plaintiff in the violation.
Correct.
That cannot, there is a clause for arbitration.
Arbitration. And the CMP was filed before this court. In the CMP, this court has appointed the arbitrator. Yes, sir.
But after the appointment of arbitrator, they also had appeared before the arbitrator.
Correct.
I would like to submit the order sheet of the arbitration. They also has claimed counterclaim.
Yes, very well. Very well. Before the arbitral tribunal. Yes.
They have filed the counterclaim.
Before the arbitral tribunal. Yes, sir.
After that, the arbitrator gives findings in his order at page number 81, issue number 5. In view of the respondent failing to produce copy of the pleadings of two suits filed against the claimant in the civil court,
yes,
and leads the evidence on said issue, I am of the opinion that the respondent.
All the defendants are contesting different.
Yes. Yes.
Of the suit OS number 6712 but 2018 and OS number 8172 but 2018.
Yes, sir.
The civil court at Madurai and Bangalore. Respectively, the claim statement is not maintainable as government by para 57 of the objections.
Yes, sir.
Addition number 5 is answered negative. Lord, when the suit is filed, when the suit is before the arbitration court, there is a bar of.
Whether the arbitral award was challenged under section 34?
They are not challenging the arbitral award.
Not challenged.
We have challenged. Lord, we didn't get any information. You are to get.
Yes, sir.
We have, within 15 days, they should.
Of course, now they have challenged the arbitral award under section 34 of the Act.
But when there is an arbitration proceedings going on, there will be a stay for the civil court to interfere in the matter. And according to section 5 of Partition Constitution of 1996, it clearly states that nothing is anything contained in any of the law or time being enforced in matter bound by this part, no judicial authority shall intervene except so provided in this part.
1 minute. The claim of the plaintiff in the present suit was not a subject matter of reference in the arbitral award. That is the finding. The subject matter of the issue in the OS is not a subject matter before the arbitral tribunal.
They made a counterclaim.
That is the finding recorded.
And so the note is also wrong. We have filed a memo stating that there is no counterclaim.
There is no counterclaim. No, the trial court rejected your application under Order 7, Rule 11 on the ground that the subject matter in the OS, that what you referred to in OS number so and so, is not the subject matter before the arbitral tribunal. Correct, Alva? Then Order 7, Rule 11 is rightly rejected.
But they made a counterclaim.
Now they are saying that.
It is recorded in the arbitral award. Getting that, the respondent.
Now they have withdrawn their counterclaim. Withdrawn?
This Lord, we have filed a memo, we are saying that we are not seeking any counterclaim, and we
Yes.
are not paid any fees also.
Even otherwise, whether they have filed counterclaim or not, the subject matter in the OS and the arbitral is different, distinct.
But there is an arbitral, I go to the agreement.
That's why the court has come to a conclusion that since the subject matter in the OS and the arbitral tribunal is different or the distinct, therefore they rejected the application filed by you under Order 7, Rule 11, in which your basis is that this is one and the same. Allah. According to you, it is one and the same. The trial court say that the subject matter, the award passed by the arbitral tribunal on 16/4/2021 is different from the subject matter in OS. That's why I asked you to
Page number 67, may kindly be present for a second.
67.
Please. The order passed in the CM.
Even otherwise, take for an example, insofar as whenever hearing the application order 7, Rule 11, the amendments made in the plaint has to be looked into. Yes, irrespective of whatever the defense that you have taken in the, that's a well settled principle. When such been the case, the trial court is justified.
Moreover, they are not filed written statement. There is no defense at all in the suit.
They are not
They are not filed written statement.
It was that time the arbitration was going on. So we're not kindly granting the permission to write.
Not a case for interference. Not a case. Dismiss. Reasons to follow. Just I have to finish remaining 2. Reasons to follow them.
33, my lord.
1 minute. 33, sir. Yes, sir.
33, I am appearing for the petitioner's counsel.
Yes, sir. What your
Sir,
challenge?
the last occasion, what was transferred, I wanted to brought into your lordship's notice. Of course, it may not, it is recorded or not recorded, I don't know.
Just I will look into the order sheet. 1 minute.
When I have argued the matter, my lord.
At the request of the London Council appearing for the petitioner, list on today.
It's only the order. Anyhow,
That was on 23/2/2022.
correct. What has happened on that day, my lord? I was insisted to take up some order to be passed. What I made in request in IA number 7 before the trial court. Your
Yes,
lordship may kindly go to page 271, Annexure J.
Yes.
This is the IA number 7.
Yes, sir.
That the IA number 7, my lord, your lordship will get the prayer at page 276.
Page?
Page 276 prayer is there on IA number 7.
Correct, sir.
My lord, in which I sought for only an order of injunction restraining not to change the nature of the land
Nature of the restraining the
and
dependent
putting
by
up any construction.
construction.
Then this was insisted. Of course, I made an argument referring to all the applications. However,
Yes.
my lord, the
Now
lordship,
what has happened? The trial court has issued notice.
yes,
Issued notice. However, you say that after hearing the other side, it will pass on.
my lord, it appears, my lord, there is that order is
Only
required to
thing
be
is, I think
corrected.
it is a disc.
That order required to
Yes,
be
yes,
corrected.
yes,
Therefore, my lord,
Yes, Rajgopal sir, you are aware. Yes, Rajgopal sir, you are well aware. Granting of injunction or refusing is.
my lord, I could
the
I could certainly agree with that.
Only thing
But
is, what best I could do
yes.
is I can direct. I can direct the trial court to consider your application within 2 months from
Can I
now.
persuade this, my lord? 1 minute. Can I persuade for this?
Because it's a discretionary.
My lord, if discretionary, I can agree with that. If on the logical issue, my lord, if a lordship wanted to hear the matter, I can argue on the point itself. My lord, may kindly have order
No,
39
sir,
rule
do
1
one
and
thing,
4.
sir. Let the trial court will consider your application and pass appropriate orders after hearing the other side within 2
My lord,
months.
after hearing the other side, there are about 50 defendants are there, my lord.
No,
All
no,
are
very-
contesting defendants.
Very well,
Unless
very
and until all the contesting defendants are served, I could
I
not
will,
able to.
I will say within 2 months from today. Better. better. That is because the court will, let the trial court will apply its mind. Because in the initial stage, it say that I've heard the plaintiff side. At this stage, plaintiff have failed to make out prima facie case.
That appears to be not correct. I wanted to say so.
Hence, it is
That
just
finding
necessary
appears to be not
hear
correct.
the other side before passing any interim order.
That finding appears to be not correct. It is not amounts to a exercise of discretion in a manner known to law is my grievance.
That's why.
I would argue the matter, then afterwards I could.
The court has come to a conclusion that let the court will hear the other side.
Therefore, last occasion also, I do agree so far as exercise of discretion in respect of IA number 1 to 6 are concerned. So far as IA number 7 is concerned, I insisted the lordships earlier who heard the matter, Honorable Justice Kinigi, and who made put a question to me, have you produced any document to show so far as changing or alteration of the land in question is concerned? He asked me a specific question about production of the photograph. When I took time to produce the photograph, matter was urgent, enabled me to produce the photograph. That was transpired, my lord, on last occasion. If your lordship necessary, I can file an affidavit to that effect also.
No, not
it was transpired. Therefore, now a memo is filed in which, my lord, I produce the photograph to show.
Yes, Rajgopal sir. No. Since great respect to you, it's better to let the court will apply its mind. Within 2 months, I will say. Let them consider your application. Let them pass, either reject or they may pass grant interim order in favor of you.
My lord, I would like to put it in this way.
Yes.
I am not pressing IA number 1 to 6 before the trial court unless the notices are served. At least trial court may consider IA number 7, my lord. Next week I will argue the matter.
IA number?
IA number 7, which I read to your lordships now.
Which one is? IA number 7.
Number 7, for not to alter and put up the construction.
Very well. That's good.
Your lordship may kindly trial court be considered this IA number 7 without awaiting service of notice to others.
No, that I cannot say. That they will consider IA number 7. Where is that IA number 7?
IA number 7 is at page 2271. This is the application which you have filed before the trial court. This at least may kindly be considered.
Annexure T. Yes.
Annexure T, my lord.
Yes, very good. Third, Sri M.R. Rajgopal and her senior counsel appearing for the petitioner. The order dated 11/2/22 on IA number 1 and 2 are impugned in this petition. Senior counsel appearing for the the trial court, having taken note of the averments made in the plaint as well as the respective applications within bracket IAS number 1 and 2, has observed that the plaintiffs have failed to make out prima facie case as well as balance of convenience, and accordingly stated that in order to pass appropriate orders on IA number 1 and 2, necessitated to hear the other side before passing any interim order on IA number 3 to 7. Sri M.R. Rajgopal and her senior counsel appearing for the petitioner contended that despite the said order passed by the trial court, in view of the urgency pleaded by the plaintiffs to protect the suit schedule property, the trial court be directed to consider the IA number 7 at the earliest. This court find force in the submission made by the senior counsel and therefore direction is issued to the trial court to consider the IA number 7 within 2 months. IA number 7 of 7 filed by the plaintiff under
Filed under order 39.
39 rule 1 and 2, read with section 151 of CPC within 2 months from today.
Not from 2 months, my lord. Within 20 days, your lordships may find this.
Within-
Therefore, I am not pressing IA number 1 to 6.
Within 1 month from today. Within 1 month from today, and pass appropriate orders in accordance with law. It is also made clear that this court has not expressed any opinion on the said application, and the trial court shall consider the same independently.
Much of.
In terms of the above, the writ petition is disposed of. Yes, sir. Sunil S. Narayan. Yes. So petition is a plaintiff. Yes, sir. What your challenge, sir? Yes. Yes, sir.
In the written statement, the defendant have mentioned 2 documents.
Yes.
3 documents. Basis where I have got the property, that is the condition.
Yes.
Now the matter is supposed to be for argument.
Yes, sir.
I
Suit.
was under the impression that our
Yes.
master will produce matter in that.
Yes, sir.
They are not produced. My only is that they produce my marker.
Yes.
Before passing the judgment, the trial court let it look into that document. Because on that, relying on that document.
This is
they are
not a
making
suit. This is not a suit for declaration.
It is a suit for declaration and permanent injunction.
This is a suit for.
Declaration and permanent injunction. Trial court has rejected only on the grounds that under Article 11 to 15 at any stage of the law, it is only during the.
And it is filed in 2015. Defendant number 1 has taken statement itself. Yes, sir.
Trial court has rejected application only on this Article 11 to 15 basis may not reject
Issue emergent notice. When a counsel appearing for the petition is also permitted to serve copy to the land counsel representing parties, you move it immediately. You list on next week one date. Next week one date. Next week. Next week one date. No, let us we will see. No, well reasoned judgment. Let us, I wanted to see since it's a suit for declaration. For that purpose I am issuing. No. I think insofar as the except 35, 37 to 48 I may not take them. Because 230 matter is there. It will take, I think today is the 3rd day.
41
wherever the interim order is there, it will be extended. Wherever. So take up any date next week. Take it up any next date. Next date of your choice, please take dates. And wherever the interim order is granted, it will be continued. Because since the 230 matter will take the entire, it may not be taken.
May I make a submission, Your Lordships? Your Lordship, serial number 44. If your Lordship may fix a date next week, my Lords. A decree has been obtained against a dead person.
Yes.
Fraudulent decree has been obtained.
Yes, yes. Let us will see.
Please.
Very good.
Court officer.
What officer? What officer?
Court officer?
What officer? Dots botave. First ಹಾಕ್ಬಿಟ್ರೆ ಟ್ಯಾಪ್ ಸ್ಪೀಕ್ ಅಂತ ಮಾಡ್ಬಿಡ್ತೇವೆ ಏನೇನೋ ಆಯ್ತಲ್ಲ ನೋಡಿ
ದನಿನೂ ಬೇರೆ ಇಲ್ಲ ಒಳಗೆ ನೋಡಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಒಂದು 2 ನಿಮಿಷ ಸರ್ ಹೇಳ್ತಾರೆ ಸರ್. ಅದು ಚೇಂಬರ್ ಕಳಿಸ್ತೀವಿ ಸರ್, ಚೇಂಬರ್
ಇಷ್ಟು ತಗೊಳ್ಳೋದಲ್ಲ ಅಂತಂದ್ರು. $230 ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆ ಅಂತ
ಸರ್. ಥ್ರೂ ವಿ ಸಿ ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಇಂದ ಡೇಟ್ ಬೇಕಾದ್ರೆ ಕೇಳಿ ಸರ್. 37 to 46, 48.
ಯಾಕೆ ದನಿ ಇದೆ ಅದು? What is the serial number 49 final hearing? ತಗೊಂತವ್ರ?
ತಗೋತೀನಿ ಅಂದ್ರು.
ಹೌದ್ರಾ?
48 ವರೆಗಿಲ್ಲ.
48 ವರೆಗೆ ಅಲ್ಲ 230ಗೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತಿದೆ. ಅದಕ್ಕೆ ನಮ್ದು ತಗೊಂತಾರ ಇಲ್ವ ಅಂತ ಅದಕ್ಕೆ.
ಚಿಕ್ಕನ್ ಗೌಡ್ರು ನೋಡಿದ್ಮೇಲೆ ತಗೋದೇ ಇರ್ತಾರ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಅಲ್ವಾ? ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ನಿಮ್ಮನ್ನ ನೀವು ರೆಡಿ ಇದ್ದೀರಿ, ತಗೋತಾ ಇರ್ತಾರ.
ಅದ ರೆಡಿ ಇದೇವೆ, ಆದ್ರ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ 230 ಒಂದು ಮ್ಯಾಟರ್ ಇದೆ.
ಅದೇ ಹೇಳಿದ್ರೆ 230 ತಗೊಂತೀನಿ, 48 ವರೆಗೆ ತಗೊಳಲ್ಲ ಅಂದ್ರು. 49 ಹೇಳಿಲ್ಲ. 2:15 ಬಂದ್ ಕೂಡಲೇ ಕೇಳಿ.
ಹೌದು ಸರ್, ಹೌದು. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 44.
44 ಡೇಟ್ ತಗೊಂಡ್ರು ಸರ್. 17/3ಗೆ ಯಾರು
ಯಾರು
ಇಲ್ಲಿ ಬಂದಿರು ಫಿಸಿಕಲಿ 17/3 ಕೊಟ್ಟಿದ್ದೀವಿ. 44
ಪೆಟಿಷನರಿಗೆ ನಾನು
ಯಾರು ಹೇಳಿ ತಗೊಂಡ್ರಲ್ಲ, ಮತ್ತೆ ಸಾಹೇಬ್ರು ಕೊಡಿ ಕೇಳದವ್ರಿಗೆ ಅಂದ್ರು. 17/3 ತಗೊಂಡಿದ್ದೀರಾ ನೋಡಿ. 44
48 ಏನಾಯ್ತು ಸರ್?
ಸರ್
48 ಡೇಟ್ ಕೊಟ್ರಾ?
18/3
sir, 43 sir.
43 16/3 madam.
Is it physical or can I come through virtual sir?
ನಿಮ್ಮಿಷ್ಟ ಮೇಡಮ್. ಎಸಿಲೈ.
Okay sir, thank you very much sir.
ಇವರೇ 44 ಇದು 12732 ಅದಾ?
ಎಸ್ ಸರ್. ಅದೇ
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಬಂದಿದ್ರು?
ಇಲ್ಲ, ಸುಮಾರು ಜನ ಇದ್ರು. ನಾವು ಯಾರು ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡಲ್ಲ. ಅವ್ರು ಕೇಳದಾಗ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ವಿ. ಯಾರೋ ಬಂದಿಲ್ಲ.
23rd ಅಥವಾ 24th ಹಾಕ್ಬಿಡಿವ್ರೆ. ಅದೇ ಹೇಳಕ್ಕೆ
ಅಲ್ಲ, ಅವತ್ತಿಗೆ ತಗೊಳ್ಳಿ ಸರ್ ಬೇಕಾದ್ರೆ ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಹೊರಟೋಗ್ಬಿಟ್ಟಿದ್ರೆ ಅವ್ರು ಯಾರಂತ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಪುನಃ ಅವ್ರಿಗೆ ಕನ್ವೆ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ನೀವು 17/3 ಬರುತ್ತಲ್ಲ, ಅವತ್ತಿಗೆ ನೀವು 24ಗೆ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ.
ಓಕೆ ಬಿಡಿ, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕು. ನಾನು
ಮಾಡ್ತಾರೆ. ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಅಲ್ಲಿ ಇದ್ದದೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ.
ಅವರು ಇಲ್ಲ ಬಂದಿಲ್ಲ ಬರ್ತಾರ್ರಿ ಅಂತ ಹೇಳಿ. ಬರ್ತಾರ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಫೋನ್ ಹೊಡಿತಾನೆ ಸಾರಿ ಎರಡಿದೆ ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ
ನಾವು ಫೋನ್ ಮಾಡಿದ್ರಲ್ಲ ಅವಾಗ ಕಾರ್ಯಾಚರಣೆ ಮಾಡಿಸ್ಬೇಕಾಗಿಲ್ಲ ಸರ್.
Yeah.
Reasons to follow.
Lordship's kind leave.
Yes, sir.
That's serial number 49.
Yes, sir.
ಅದ್ರಾಗ ಈಗ 230ಗೆ ಒಂದು ಮ್ಯಾಟರ್ ಕಮೆನ್ಸ್ ಆಗುತ್ತೆ ಅಂತಂದ್ರೆ ಈಗ ನಮ್ಮ 49 ತಗೊಂತೀವಿ.
Mr. S.C. Shivaram, he had appeared and he said he is representing the petitioner. I think he has filed power ante actually.
Malas?
Mr. S.C. Shivaram has filed power in this. Or Madidro, I think his name has been removed. So on being saying that he has been designated as a senior advocate. Today morning he submitted that his name has to be shown. Anta.
Arjan Malas.
Arjan yavattu hogiru. Next week anta agidi.
ಹೌದು.
49 is urgent to next week.
Please.
Reasons to follow ಅಂತ ಮಾಡಿದ್ಮೇಲೆ ಯಾವುದು ಒಂದು ಫೈಲ್ ನಿನ್ನೆ ಎಷ್ಟಾಗಿತ್ತು ನಿನ್ನೆ ಇವತ್ತು ಎಷ್ಟಾಗಿದೆ ಹನ್ನೊಂದು serial number 32 I get directed one. WP number 4104. Dependent in OS number in dependent in COM OS number commercial COM dot OS number 8172 of 2018 on the file of the 86 additional city civil judge at Bengaluru has preferred this writ petition, challenging the order dated 17th November 2021, dismissing the application number 2 filed under Order 7 Rule 11 of CPC, read with Section 8 of Arbitration and Conciliation Act 1996, dated 1/12/2016. Plaint, just brief facts for adjudication of this writ petition are that the plaintiff has filed suit for recovery of money of rupees 1 crore 79 lakhs 75,898 with interest based on the agreement dated 1/12/2016. It is forthcoming from the facts of the case are that the plaintiff and defendant have entered into an agreement dated 1/12/2016, under which the defendant had agreed to pay 3% on the total investment of 1.3 crore at rupees 4 lakhs per month to the plaintiff, and the same was and the said case was contested by the defendant. The defendant has filed application under Order 7 Rule 11 of CPC for rejection of the plaint by contending that that in terms of the order passed by this court in a CMP number 46 of 2018, under Section 11 of Arbitration Act, Arbitration Act of the Arbitration Act, this court has appointed the arbitrator to resolve the arbitral dispute between the plaintiff and the defendant, and the arbitral tribunal by award dated 12/3/2020 passed a award on 16/4/2021 and it is the contention of the defendant is that in view of the arbitral award passed in AC number 104 of 2020, AC number 104 of 2020, the suit is not maintainable. The said application came to be dismissed by impugned order dated 17th November 2021. And as such, the defendant has presented this writ petition. I've heard Sri B.S. Gautam. B.S. Gautam, Learned Counsel appearing for the petitioner, and Sri M. Dinesh Rao, Learned Counsel appearing for the caveator respondent. Sri B.S. Gautam, Learned Counsel appearing for the petitioner, contended that the trial court ought to have dismissed the ought to have allowed the application by dismissing the suit, as there is no cause of action to file the suit. He further contended that the issue in the suit has been resolved by the arbitrator in AC number 104 of 2020, and therefore the suit is not maintainable. Per contra, Sri M. Dinesh Rao, Learned Counsel appearing for the respondent caveator, sought to justify the impugned order. In the light of the submission made by the Learned Counsel appearing for the parties, it is a well-established principle that it is the duty of the court to consider the averments in the plaint while considering order application and order 7 Rule 11 of CPC. The trial court by impugned order had given a finding that the claim made by the plaintiff in the suit is not the subject matter of the reference before the arbitral tribunal in AC number 104 of 2020. Arbitral tribunal has passed the award pursuant to the order passed by this court in CMP number 46 of 2018, and therefore I am of the view that the finding recorded by the trial court is just and proper and does not call for any interference in this petition. Accordingly, the petition is dismissed as devoid of merit. Yes. Pass over again. 30, 35. it's a 2016 matter. Yes. Yes, sir. What is impugned in this? MA. Yes.
The facts of the case is the respond number 2 and 3 Bescom. Respond number is 9. The Bescom has given a certain contract worth 26 crores to the petitioner.
Yes, sir.
And when the petitioner has executed the work,
yes,
for certain extent, not being satisfied about the pace of the work, they are short circuited.
Yes, sir.
And then they have terminated, and the performance guarantee given by me to the extent of 2.61 lakhs 23,000.
Yes, sir.
They wanted to the bank guarantee for that, which I challenged before this honorable court, and this honorable court, since it is a question of the disputed fact, whether the notice is valid or not, this court cannot decide on this fact.
Question of facts. Correct.
So I entered federal suit and sought for injunction.
Yes.
The injunction was rejected, and then appeal was filed. Appeal was in the appeal will also my player.
Yes.
Now, there is a development in this one. The Westcom has acted memo on the last hearing day.
What is memo? No?
Memo along with two documents. 15 to 22. 15 to 22. Last hearing day.
Memo, sir. Yes.
Now, we also can you see the document number 1?
It is a written statement.
No, in this memo.
Memo is filed. Ravindra Reddy. You also filed a memo with it. 15 to, yes, sir. Correct. Copy of the letter dated 9/8/2017. Correct. Correct. Correct.
Now, the Westcom, my suit is still pending. Anyway, the Westcom has calculated liquidated damages and other things and worked how much I have done and how much they are entitled according to them.
So 3 crores 80 ಅಂತ ಏನು ಹೇಳಿದ್ರು?
Our 3 crore 80 lakhs they have to pay back. After adjusting this liquidated damages as well as the other charges paid.
Yes, sir.
Now, what my humble submission is, subject to the result of the suit, this writ petition may be disposed of and they will direct to pay this 3 crore 80 lakhs to me. Anyway, whatever amount they are claiming from me will be with them till I mean, suit is completed. And if I am able to establish the suit that the entire thing is illegal, then I am entitled for that money with damages. Otherwise, the money is already recovered.
Always do one thing. That the trial court will take a note of this and pass appropriate. Yes. 1 minute. 1 minute.
I will always take it up. And I have to establish damages everything. Now, even according to them,
You know what I'm saying?
amount of 3 crore 80 lakhs.
And just do one thing, because 227 insofar as MA is concerned is very limited.
No, I don't understand.
That's why what I will do. I will say that this memo be considered by the trial court and take appropriate decision. Because in the event, if I say that I accepted this amount, then it is a finding on that thing. The trial court cannot adjudicate.
ಇದು ನಾನ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಲ್ಲ.
ಅವರೇನೆ. Let the court
admitted amount which is payable to me.
Let the court will trial court will apply its mind. So far is better, I think so.
ಅಲ್ಲ ಇದು ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಇದು ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. No, this is subsequent ಆಗಿದೆ. ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ಇರೋದು ದಿ ಇನಿಷಿಯಲ್ ಅಮೌಂಟ್ ಆಫ್ ನನಗೆ ಕೊಡಬೇಕಿತ್ತು ಅಂತ ನಾನು 10 crores ಹಾಕಿದ್ರೆ.
Yes.
ಅವ್ರು ಏನು ರಿವೋಕ್ ಮಾಡಿದ್ರು ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ. ಕಾಂಟ್ರಾಕ್ಟ್ ರಿವೋಕ್ ಮಾಡಿ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿದೆ.
I will say the trial court will consider this and pass appropriate orders in the meantime.
ಅಲ್ಲ ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ
No, within a time frame.
1 month or 2 months. ಯಾಕಂದ್ರೆ ಈಗ ನಾವು
Yes, it could be done. It could be done. So I will say registry may even forward this document to them. Better. Yes. Till do one thing till because bank that is different number 1.
ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅದಕ್ಕೆ ನಾನು ಗಮನಕ್ಕೆ ಏನಾಗುತ್ತೆ ಈಗ 2 crore 51 lakhs ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿನು ಇವರು ಇನ್ವಾಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರು ಈಗ ಇಂಟರ್ವ್ಯೂ ಮಾಡೋ ಟಿಕೆಟ್ ಆದ ತಕ್ಷಣ ಅವರು ಅದನ್ನ ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ. ನಾವು ಎಂಟೈರ್ ಅಮೌಂಟ್ ಅಂದ್ರೆ ನಂಗೆ 380 ಕೊಡೋದಿದೆ, ಅದ್ರ ಬದಲು ಅವರು ಆಲ್ರೆಡಿ ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರ ಎಲ್ಲರೂ ಇರ್ತದೆ. ಐ ಆಮ್ ಆನ್ ಇಂಡಿವಿಜುವಲ್.
So no till the order passed by the court on these memos, interim order granted by this court will continue.
ಅಲ್ಲ
ಹಾಗೆ ತಗೊಳ್ಳಿ ಸರ್ ಮಾಡ್ಬೋದು. Yes, madam. Yes, madam. So, madam, in so far as this concerned, I think very limited. No, very limited under 227. I think writ petitions fails. However, that's what I'm saying. ನಾನು ಅದನ್ನೇ ಹೇಳಿದ್ದೆ. No, it is your document actually. This is filed by you. That's a different. Yes.
ಅದು ಅವ್ರ ಇನ್ವೊಕೇಶನ್ ಏನ್ ಮಾಡಿದಾರೆ
Please sit down.
ಇದನ್ನ ಏನ್ ಮಾಡಿ ರಿಕಾಲ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಅನ್ನ ದಟ್ ಈಸ್ ಇಲ್ಲೀಗಲ್ ಅಂತ ನಾನು ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಅಂಡ್ ದೆನ್ ಫಾರ್ ಡ್ಯಾಮೇಜಸ್
Yes.
ಇಲ್ಲಿ ಇರೋದು ನಂದು 10 crores ಅವ್ರು ಕೊಡೋದಿತ್ತು ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ 3 crore 80 lakhs ಅವ್ರು ಕೊಡಬೇಕು ಅದನ್ನ ಅವರೇನು ಕಳಿಸಿದ್ದಾರೆ ನಾನು ಮಾಡಿದ್ದಾರೆ.
So I will say the writ petition space, however, insofar as till that interim order granted by this court, ಯಾವಾಗ ಕೊಟ್ಟಿದೆ interim order? Interim order granted only. Parties to maintain status quo ಅಂತಲ್ಲ, that is 10/2/2017. 10/2/2017 shall continue till the Yes, madam. Consider in the light of the memos that you have filed. Nothing will happen. Nothing will happen to the corporation.
My money is there, excess over and above.
Because their money itself, 3 crores is lying with you.
The excess, 3 crores is excess. After adjusting, now you ask my NDC. I will just point out your also NDC.
Bank guarantee.
Bank guarantee. Literally,
that is 2 crores 61 lakhs 23,322.
ಅದು ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ.
ಹೌದು.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಅಮೌಂಟ್.
Yes.
ಅದಕ್ಕಿಂತ ಮೊದಲು ಟೋಟಲ್ ಅಮೌಂಟ್ ಅವರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ರಿಟೆನ್ಷನ್ ಅಮೌಂಟ್ ಫ್ರಮ್ ಬೆಸ್ಕಾಮ್ ಅಂಡ್ ಸ್ಕಿಲ್ ಟೆಕ್ ಡ್ಯೂ ಫ್ರಮ್ ದಿ
That the trial court will take.
This ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ ಮೇಲೆ 3 crore 80 lakhs total amount due from skill tech to ಬೆಸ್ಕಾಮ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
It may be adjusted towards whatever that they have admitted in the before the trial court. This petition. Please run. Please run.
ನಾನು ಇನ್ನೂ ತೋರಿಸಿಲ್ಲ. ಲಾಸ್ಟ್
I know. Which one?
ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್. ಅದು 23 July 2019.
Top fine ಮಾಡಿರೋದು. That is 15/2.
ಅಲ್ಲ 23 July 2019.
23.
ಅಲ್ಲ ಇದೇ ಮೆಮೊದಲ್ಲೇ ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಇದೇ ಸೇಮ್ ಮೆಮೊದಲ್ಲಿ.
ಅದೇ ಮೆಮೊದಲ್ಲೇ ಲಾಸ್ಟ್ ಇದು ಲೇಟೆಸ್ಟ್ ಅವರು
ಅದೇ 3 crores 51 ತಾನೆ.
ಅಲ್ಲ 3 crore 51 ಸಿಲ್ಕ್ ಟೆಕ್ ಗೆ ಪಾವತಿಸಬೇಕಾದ ಬಾಕಿ ಮೊತ್ತ ಅದೆಲ್ಲ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ಎಲ್ಲದೂ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ
3 crore 51,000.
3 crore 51 ನಾನೇ ಕೊಡಬೇಕು. ಆದ್ರೆ ಇದೆಲ್ಲ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ ಏನೇ ಡ್ಯಾಮೇಜಸ್ ಚಾರ್ಜಸ್ ಎಲ್ಲ ಹಾಕಿದ್ರಲ್ಲಿ ಸಾಮಗ್ರಿಗಳನ್ನು ಬದಲಿ ಗುತ್ತಿಗೆ ಸಾಮಗ್ರಿಗಳು ಮೊತ್ತ ಕಡಿತ ಮಾಡಬೇಕಾದ ಲಿಕ್ವಿಡಿಟಿ ಡ್ಯಾಮೇಜಸ್ ಮೊತ್ತ ಇವನ್ ಡ್ಯಾಮೇಜಸ್ ಹಾಕಿದ್ದಾರೆ.
Yes.
ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ನಾವು 351 ಅವರು ಕೊಡ್ಲಿಕ್ಕೆ ನಾನು ಕೊಡ್ತೇನೆ ಅವ್ರ ಅಮೌಂಟ್ ರಿಕವರಿ ಮಾಡೋದು ವಿತ್ ಡ್ಯಾಮೇಜಸ್.
No, let the court be sorry. No, we have to go by your letter. That's all. Nothing much. This writ petition is filed by the plaintiff. Please run. Plaintiff in OS number 352 of 2014 on the file of the 4th additional senior civil judge at Mysuru, challenging the order dated the 1st December 2014 and the order dated 21st November 2016 in MEA number 64 of 2014 on the file of the 1st additional district judge Mysuru, dismissing the application filed by the plaintiff on IA1 filed under Order 39 Rule 1 and 2 of CPC. Brief facts for adjudication of this writ petition are that the plaintiff has filed suit for declaration that the short closure notice dated 19/10/2013 issued by the defendants 2 and 3, terminating the contract of the plaintiff is null and void, and also seeking declaration that the letter dated 22/1/2014 seeking order of forfeiture of the bank guarantee and the deposit as null and void, with consequential relief of permanent injunction restraining the defendants 2 and 3 from invoking the bank guarantee dated 5/4/2011 bearing number 14/2011 with the first defendant bank. Along with the full stop. Along with the suit, the plaintiff has filed application and Order 39 Rule 1 and 2 seeking ad interim order of temporary injunction restrain the defendants from encashing the bank guarantee and the trial court by order dated one nimsham. But KPTCL has filed objection to the application. You are not. No, you filed statement of para 7. This is said application. Filed IA number 13 seeking bank. Chur font. The said application. The 39 ad interim so and so. The said application was opposed by the defendants by filing statement of objection, and the trial court, after considering the material and record, by its order dated 1st December 2014, dismiss the IA number 1 filed by the plaintiff, and being agreed by the same, the plaintiff has filed MA number 64 of 2014 on the file of the first additional district judge Mysuru, and the said appeal was resisted by the defendants. The first appellate court, after considering the material and record, by its order dated 21st November 2016, dismissed the appeal, and being agreed by the same, the plaintiff has preferred this writ petition. I heard Mr. So-and-so on a counsel appearing for the petitioner and Madam so-and-so on behalf of Sri Ravindra Reddy for the caveator / respondent number 2 and Sri SKM Shetty on a counsel appearing for the respondent bank. 2 and 3. Rescom 2 and 3, yes. 2 and 3. 2 and 3 for the madam, Mr. SKM Shetty for respondent number 1. Then a counsel appearing for the petitioner contended that both the courts below have not considered the fact that allowing the encashment of bank guarantee would result in irreparable harm and injustice to the petitioner. he further contended that the plaintiff has made out a case for prima facie that non-granting of temporary injunction would result in irretrievable loss being suffered to the plaintiff company, plaintiff company. And therefore, he sought for interference of this court. Per contra, and a counsel representing the respondents sought to justify the impugned orders. During the pendency of this petition, the plaintiff/petitioner have filed memo dated 15/2/2022 and sought to file certain documents for consideration of this court. Likewise, the defendant corporation, respondent 2 and 3, have also filed certain documents for consideration of this court. Perusal of the letter dated 9/8/2017 and 23rd July 2019 issued by the respondent corporation would indicate that would prima facie indicate that the respondent corporation undertakes that they owe rupees 3,51,57,020 as per letter dated 23rd July 2019 to the plaintiff company. On the other hand, the documents produced by the respondent corporation according to the Lena Council estimate, according to Lena Council appearing for the respondent corporation, 1,33,698 that the respondent corporation owe rupees 1,33,980,698 rupees to the plaintiff company. Taking into consideration the arguments advanced at the bar, this court is of the opinion that the power to be exercised, the jurisdiction to be exercised by this court under Article 227 of the Constitution, insofar as the concurrent findings made by both the courts below on the application under Order 39 Rule 1 and 2 is very limited. And that apart, both the courts below have fairly appreciated the material and record and had come to a conclusion that the plaintiff has not made out a case for granting of interim injunction as prayed in IA number 2. Perusal of the reasons would indicate that that both the courts have come to a conclusion that insofar as the delay in the project, same be compensated in terms of money. And actually, and therefore, therefore, the court has arrived at a conclusion that the claim made by the petitioners / plaintiff request to be adjudicated on merits after full-fledged trial. In that view of the matter, I do not find any acceptable ground to interfere with the impugned orders passed by the courts below. However, taking into account the memos referred to above filed by the plaintiff as well as the defendant corporation, I am of the view that these memos has to be considered by the trial court, and pass appropriate orders at the earliest within 2 months from the receipt of these memos from this court. In the meanwhile, in order to protect the interest of the petitioner / plaintiff, I am of the opinion that the interim order dated 10/2/2017 passed by this court shall inure to the benefit of the petitioner / plaintiff till the consideration of the memos by the trial court at the as observed above. In terms of the above, the writ petition is disposed of. ಅದು ಗ್ಯಾರಂಟಿ ಅದಿದ್ದೇ ಇರ್ತದೆ. ನೀವು ಓದ್ಬಿಡಿ ಜೋರಾಗಿ, ಅದನ್ನು ಮಾಡಿಕೊಟ್ಟು. The observation made by this court may not come in the way of the trial court to dispose of the petition on merits. Yes. Joshua Hudson, Miss Samir. Yes, ma'am. Yes, petition. Yes, remaining matters have been adjourned, Sitramaya.
Yes, please, madam.
I think from 36 to
Yes, please.
48 have been adjourned in the morning itself. Yes, sir.
To which date, madam?
What is your serial number?
36, madam.
38.
Sorry, 38.
18th.
Yes, please.
39 ಹೇಳಿ. ಏನಾಗಿದೆ ಅಂದರೆ ದಿನ 60 ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಕಷ್ಟ ಆಗ್ಬಿಡ್ತದೆ. 17th ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ. 39 ಅಲ್ಲ, 17th. ಹಾಂ, ಎಲ್ಲದರಲ್ಲೂ ಇಂಟ್ರಿ ಮಾಡೋ ವೇರ್ ಇಟ್ ಇಸ್ ದೇರ್ ಇಟ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್, ನಥಿಂಗ್ ಟು ಬಿ ವೇರ್. ಇದು ಕೊಡಿ ಸರ್, ನಂಬರ್ 55. Yes, he has to continue. Facts ತಗೊಂಡಿರ್ತೀವಿ, facts. 230. Please, sir. Barley. Just facts I will. Oh, yes, come.
I'm ready.
Please.
Sir, I was in the other board. I'm so sorry. I'll finish it.
So, both of you have to finish today.
I will finish.
You have to make way for them also to finish.
I'll not.
Because what will happen?
I'll come now to the fragment of
That's it.
only with regard to those two judgments.
Yes. Yeah, that's good.
One is MK. I'm sorry. I'm so
Just
sorry.
before, I think.
The Krishna Murthy wants to make a submission. I'm sorry.
Send the reference. ಹೇಳಿದ್ವಲ್ಲ ಹೇಳಿದ್ರೆ ಹೇಳಿದ್ವಿ ಅದನ್ನು ಮಾಡಬೇಕು ರಿಜಿಸ್ಟರ್ ಅದನ್ನು ಸೇರಿಸ್ಬೇಕು ಎಸ್ ಪರವಾಗಿಲ್ಲ ಎಸ್ ಸರ್ ಜಸ್ಟ್ ಬಿಫೋರ್ ಗೋಯಿಂಗ್ ಟು ಜಸ್ಟ್ ಫಾರ್ ಮೈ ನಾಲೆಡ್ಜ್ what is the acceptance of the written statement 120 days now law as on today?
No, now it is extended by 90 days. What the Supreme Court has said is the limitation will stand extended to 28 of February. Thereafter, 90 days time.
From
So,
February
28.
From this?
From March 1st.
From this.
From March
Another
1st.
90 days.
Another 90.
What is in the there is 120 days, what is there in the commercial?
That is the commercial code, sir.
What is the law on that aspect actually?
No, that the Supreme Court recently has come
That's what.
clarified, saying that.
That is one writ petition went from Chennai.
Sir, precisely. Yes.
Chennai court, the High Court, that say that even it may be extended.
It has to be extended because the Limitation Act applies. Because of the order of the Supreme Court on 24th of March 2020, they said that it will apply to even 5 minutes.
That was only in so far as the SOP of Apex Court.
Yes.
Apex Court. Otherwise?
Otherwise, 120 days, you lose your forfeit. You forfeit. That's all.
So it is only this.
No, sir. Having said that, great respect. We never know when it will be. They said that it's only
mandatory.
Having said that, I'm not going to say.
Salem Advocates Association.
Yes, correct. Salem Advocates Association.
That's a constitution bench judgment.
Yes,
yes. Just I want to clarify my mind.
I also took the notification to the court officer tomorrow. I have taken it out and I kept it for some.
Oh, not for this case. For some other case.
For some other case, I give both the notifications. Whereas the Supreme Court, how the Supreme Court has clarified it earlier.
It's L. Nageshwara Sahib.
No, it is just this. I think it's Sarah.
Vinesh Saran Sahib.
Yeah. Just now. It came out
last week. It was there in the live.
Yes. It came live as well as in Baran bench.
Baran bench. Yes. Come to this now.
We are happy to know that you judges are big like law. Baran bench.
Every day we are student.
Yeah. Yeah.
And you will balance.
Because the councils are not.
Yes, sir. But let the Lana Constable complete. Please run, please.
My lord, for the fifth respondent, I am online, my lord.
Yes, very well. Sir.
What's this? The trial.
Yes.
While considering this particular aspect.
N case.
Under both annexure J.
That is 2018.
Yes.
Yes.
Both under annexure J as well as in annexure P178 refers to the judgment of MK Global.
Correct.
But in MK Global, the issue was with regard to permissions to use of the expression, I am at classical B.
Yes.
2018-9, classical B has.
Yes.
Classical E.
E.
Practice and procedure for applications made for setting aside an award under Section 34. Summary nature of proceedings under Section 34 and need for expeditious disposal thereof. Need for disposal of Section 34 applications within time limit. Framing of issues, taking of oral evidence, requirements of the use of the word permission of proof. That in Section 34, meaning and scope matters not contained in record to arbitrator when can be called for and manner in which it has to be approved. But this has been dealt with at paragraph number. I just take it directly through to page number. Page number 63 minutes and
Yes.
paragraph number 21.
Yes.
They go through various aspects. Visa developers has been noted.
Yes.
And then thereafter, the law under visa developers was very clear. They said, yes, you have the right to do it. So now under 21 minutes, I just say how they happen after going through all that. It is thus we see that speedy resolution of arbitral disputes has been the reason for enacting the 1996 Act and continues to be the reason for adding amendments to the said Act to strengthen the aforesaid object. Quite obviously, if issues are to be framed and oral evidence taken in a summary proceeding under 34, this object will be defeated. It is also on the cards that if bill number so and so is passed, then evidence in the state of section 34 application will be dispensed with altogether. Given the current state of law, we are of the view that the two earlier Delhi High Court judgments cited by CNR correctly reflect the position of law as to the furnishing proof under section 24 2A. Plus 2A to the court.
Yes.
Kindly see the word used under 2A. It is an application to be made under 34. There are two parts to section 34. 2A and 2B. So does the Calcutta. There are two parts to it. 2A, 2B.
Yes.
So does the Calcutta High Court judgment, we may hasten to add.
Correct.
We may hasten to add that if the procedure followed by Punjab and Haryana High Court is to be adhered to, the time limit of 1 year will only be observed in most of the cases in place. We therefore overrule the said decision. We are constrained to observe that visa developers was a step in the right direction, as its ultimate ratio that issues need not be stuck at the stage of hearing a 34 application, which is a summary procedure. However, this judgment must now be read in the light of the amendments made to section 34.5 and 34.6. Plus 34.5 and 34.6 came in only subsequently.
Correct.
My case is of 2012. So read, we clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, let's say qualified.
Yes.
If there are matters not contained in such record and are relevant to the determination of issues arising under section 34, they may be brought to the notice of the court by way of affidavits filed by both parties. Cross-examination of persons swearing to affidavits should not be allowed unless absolutely necessary. As the truth will emerge on a reading of the affidavits filed by both parties, we therefore set aside the judgment of the Delhi High Court and reinstate the letters also. The appeals are accordingly allowed.
That means court said it may be accepted.
We might accept. They may be given an opportunity. But generally, since it is a summary procedure, generally it might not.
Based on the affidavits.
Affidavits it can be done, but the party wants to cross-examine, given the opportunity. Why I am trying to say this is, I had shown that particular application IA number 75 written, where they said we want to lead evidence. It is not anyone's case that both the parties had not led evidence before the court under section 34. All we are trying to say is just give us an opportunity of producing these documents. Don't get it from us. If you can produce it, produce it. Alternatively, the architects, the authors of the document, let them produce it. And for a minute, perhaps, I am not saying that let the trial court consider this independent by hearing section 30.
Yes.
Then the subsequent judgment also is done. In Canada Nidhi Limited, wherein they go through the whole aspect, and then thereafter, at Canada Nidhi, I don't know what's the court.
We don't.
Yes,
Canada Nidhi.
This is also referred to as the trial.
Yes. Yes, sir. Paras are relevant.
The paragraph number 20, and it is coming directly.
20.
20.
So,
At paragraph 19, my lord.
so in FISA it say that Honorable Justice Ravindran Sahib.
Yes. They say that yes, it will be given.
It's a summary. Proceedings you should be as far as possible you minimize.
What the position was.
The MK say that no need to frame the issues.
Yes. Yes.
Next.
Yes. And now thereafter they say, keep it to the bare minimum. That is what I said. Earlier
Any judgment need not even adjudicate also.
Pardon?
Need not even adjudicate also. There's no judgment. So what has happened in Canada?
Yeah, in Canada.
A step ahead.
Yeah, paragraph number 19. They go into all these judgments. The question falling for consideration, paragraph 19.
Yes, the question falling for consideration
is whether present case is such an exceptional circumstance that it was necessary to grant opportunity to respondents numbers 1 to 5 to file affidavits and to cross-examine the witnesses is made. So that's all the point, which was considered. The affidavit filed by the respondents along with the applicant filed under section 151 CPC does not indicate as to what point the first respondent intends to adduce evidence except stating that the first respondent intends to adduce additional evidence relating to the subject of the dispute. That's the difference here. I have specifically said it is only for the purpose of plans, nothing more, nothing less.
Yes.
The affidavit does not disclose specific documents or evidence required to produce except stating that the first respondent intends to adduce additional evidence or otherwise. The first respondent will be subjected to hardship in the arbitration suit filed under by the rightly contended by the learned counsel. There was no specific
government in the
Then thereafter they conclude at paragraph number 21.
Yes, sir.
And last September, just above E, the High Court.
The High Court did not.
Yeah, the High Court did not keep in view that respondent 1 and 2 have not made out grounds that it is an exceptional case to permit them to adduce evidence in the application under section 74.
Only exception. Now you have to bring your case into the exception.
What I am trying to say, my respectful submission, I just sum up for the question. I'll say what they are. My case,
yes,
exhibit 61
yes,
to 68, which was marked before the arbitral tribunal.
Exhibit 61
to 68. These are the plans.
Yes.
Reference in respect of exhibit 61 to 68 and the plans are there in various exhibits which are before the court.
Yes.
There is oral evidence also to that effect, wherein there is an admission. For that limited purpose of amplifying, only because the records which are before the court are not complete. That is my case. It is not complete. I have called upon the architects to produce the complete records. That's all my case. Even from the bar I make the submission, if it can be marked by consent,
yes,
I have no problem whatsoever.
Yes.
We could just proceed to the merits on finding.
Right.
These are all.
Yes. Yes.
First to third respondents in the matter.
One minute. Third respondent, sir.
Third respondents 1 to 3.
1 to 3. Yes.
The two last submissions made by my learned friend may be borne in mind by all of us. The very last submission was the citation of the Canara in the case.
And then the second last submission was in relation to MK Global. The reason I start with that is I am going to bring my arguments squarely within the framework of these two judgments.
Correct.
MK Nidhi, 20, I will say again.
1 minute. Now, MK Nidhi, yes, sir.
20 of the
Yes, sir.
Canara Nidhi judgment.
Yes, sir.
By perusal of the award, it is seen that before the arbitrator, respondent one filed a written statement, the other respondents also filed separate written statements. It was contained in documents before. Both parties adduced only documentary evidence. The applicant or evidence for examining the witnesses also and executed documents P1 to P1. Respondents 1 and 2 also examined 5 witnesses, so also produced documentary evidence, exhibits R1 to 3. As held by the district judge, the grounds urged in the application can very well be considered by the evidence adduced in the arbitration proceedings and considered the arbitrator. Further, in the application filed by respondents 1 and 2 seeking permission to adduce evidence, no ground was made out as to the necessity of adducing evidence and what was the nature of the evidence after the respondents 1 and 3. Proceedings under Section 34 of the Act are summary proceedings and as part of the nature of the written suit and added subsections 5 and 6, Section 24. Act is specified time limit, etc. Then straight away go few lines down the law. In the arbitration proceedings,
Yes.
the parties had sufficient opportunity to adduce oral and documentary evidence. The High Court did not keep in view the respondents 1 and 2 not made out grounds that it is an exceptional case to permit them to adduce evidence in the application of the Section 34 of the Act. The said directions of the High Court amount to retrial on the merits of issues decided by the arbitrator. When the order of the district judge dismissing the applications filed by respondent numbers 1 and 2 does not suffer from perversity, the High Court in exercise of supervisory jurisdiction under Article 26.7 ought not to have interfered with the order passed by the district judge, and the interim judgment cannot be sustained. That is the first legal principle on which my learned friend had to make out the case for needing additional evidence. The second legal principle, my lord, was in the last 2 lines of para 21 in the MK Global case.
20?
Para 21,
Correct.
MK Global.
Correct.
Last 2 lines. So rare, we clarify. Last 2
So read we clarify.
So rare, we clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, if there are matters not contained in such and are relevant to the determination of issues under Section 34(2)(a), they may be brought to the notice of the court under affidavits filed by both parties. Cross-examination of persons swearing to the affidavit should not be allowed and is absolutely necessary, as the proof will emerge at reading of the affidavits filed by both parties. We therefore set aside the judgment of the High Court and reinstate back the learned additional district.
Just I would like to clarify again.
Yes.
However, please read from there. However, if there are matters not contained in such record, that is arbitral law. Yes.
And are relevant.
And are relevant for a determination of 34.
Yes, there should be 2 tests. They are not available and should be relevant. So the determination of matters issued under Section 34(2)(a). And we will just refresh our memory, my lords, on what is Section 34(2)(a).
One minute. So the plaintiff has to prove that the record is already available, he cannot take the advantage. If there is no record before the arbiter tribunal, in the event such documents is required for adjudication of the suit under 34, then it may be exceptional cases, it may be.
And an exceptional case.
It may be received.
Yes. So these are the 2 tests. What is 34(2)(a)?
34?
2A of the Arbitration Conciliation Act, because MK Global says
yes, sir.
They're relevant to the determination of the issues arising under Section 34(2)(a). Not just broad involved in your section 34 case, relevant under section 34(2)(a).
Yes.
An arbitral award may be set aside by the court only if the party making the application establishes on the basis of a record of the tribunal that one, the party was under some incapacity.
Yes.
Two, arbitration agreement is not valid under the law to which the parties are subjected it, or failing any indication thereof under the law of the time being before. Or three, the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, or was otherwise unable to present its case. Or the arbitral award deals with the dispute not contemplated by or not falling within the terms of the submissions to arbitration, or it contains matters and decisions beyond the scope of the submission to arbitration. Provided that the decisions on matters submitted to arbitration can be separated from those not so submitted, only that part of this award which contains decisions on matters not submitted to arbitration may be set aside.
Yes.
5. The composition of the tribunal or the arbitral procedure was not in accordance with the agreement of the parties, unless such agreement was in conflict with the provisions of this part from which the parties cannot derogate, or failing which such agreement was not in accordance with this part. So, MK Global has restricted leading or additional evidence to making of the ground under 34(2)(a). It does not say B, it does not say C, or any of the other matters.
Yes.
The non-production of a plan he may contain, a learned friend may contain, that it is in contravention to the fundamental policy of Indian law, most basic notions of morality or justice. But all that falls under B. It doesn't fall under 34(2)(a).
Yes.
So this is the touchstone on which this facts of this case will have to be
looked into. Correct.
Straight away I take the lordship to my compilation,
1 minute. Yes.
which are some of the records from the arbitral tribunal.
Compilation.
My learned friend has already informed your lordship about joint development agreement
Yes.
of November 1994, non-performance obligations by the plaintiffs,
Yes.
alleged non-performance by the defendants, leading to the termination in 2006, constitution of a tribunal in 2008. Tribunal has formulated certain points for determination. Straight away, lordship takes page 1 of my compilation. These specific page 1.
Page 1.
Yes, I put the 8 pages on the right. What did the plaintiff understand was the case that he needed to fight before the tribunal? The points of determination. Admittedly, the building plans which are now sought to be produced was an obligation of the plaintiffs, which is now what he seeks to produce them. First, issue number 5. Whether the respondents were the plaintiffs in the trial.
Yes.
Whether the respondents have utterly failed to comply with their obligations under the
JDA. Yes.
That is everything: plans, resolution of disputes, raising of funds, etc. 7. Whether a period of 180 days within which the building plan was required to be obtained, as mentioned in the JDA, was not considered to be mandatory clause by either of the parties in view of the subsequent developments. 15. Next.
Whether the respondents.
Whether the respondents were all along ready and willing to perform their particular obligations. So there was no doubt they knew what their case was. Just as I mentioned in Canada Nidhi, respondents 1 and 2 knew what the case was all about.
Yes.
What is the evidence they required to lead?
Yes.
So let us see now about what is the evidence that they led. Having known
straight away lordship can go to page 11 of my compilation.
Yes. Para 14.
14. And this affidavit of evidence, my lord, if your lordship sees the very last page, was filed by them on 15/6/2010, 12 years back, almost 11.5 years back. I state that V.K. Giridhar, architect, was earlier engaged by me, page 11, my lord, my compilation.
This is the affidavit of petition. Petition is here.
Before the tribunal.
Yes.
Before the tribunal. I state that Mr. V.K. Giridhar, architect, was earlier engaged by me to prepare a detailed plan for the development of the aforesaid property.
Yes.
Subsequent to the detailed survey of the property with Mr. So-and-so, who was none other than the first witness sought to be recalled by him, prepared several conceptual plans, and finally the plan for development was ready by July 2005. And though it was not incumbent upon me to show to the owners, the said plan was shown to Mr. So-and-so, who informed me to keep it on hold till the completion of the murder trial of so-and-so. The trial got continued during May 2005. The appeal and reference before the Honorable High Court disposed of in September 2005. Honorable Supreme Court gave its judgment in the matter during July 2008. Subsequently, that is to say, after July 2008, with the good offices of Mr. So-and-so, my associate in the project, and who has made investment in the project, Mr. So-and-so, architect, that is the second witness proposed to be summoned,
Engage for it.
was engaged for the preparation of the plans in respect of aforesaid property for the optimal benefit of the parties. Right?
What you mean to say that it is well within their knowledge.
That two sets of plans by the proposed first witness to be summoned and the proposed second witness to be summoned were already ready and available. They knew what the issues were. Then, second paragraph, paragraph 15.
Yes.
I state that though it was not a term of the joint development, letters dated 27/7/2005, that is Exhibit C-26 produced along with the repetition, if I'm not mistaken, at page 101 is what I was.
27/7.
Yes.
Yes.
Page?
Page number.
Page 101. Exhibit.
I'm sorry. No, the letter.
101.
No, sir. It is a page number.
Oh, sorry, the letter. That is exhibit page 104.
104, annexure.
Annexure F.
Annexure, yeah.
Annexure F is this very same letter, 27/7/2000.
Were addressed to the owners.
To address to all of them.
Yes.
Each one got a separate.
Yes, we come to that. But addressed to the owners, enclosing the copy of the development plan and the specification in line with the trend prevailing at that time for the development of the property, and sought their suggestions to be communicated at the earliest to me, as the said plan was to be submitted for approval and sanctioned by the concerned authorities, and by the communication dated 27/10/2005 by one of the owners who manifest amongst themselves that there was no consensus, blah blah blah. That's not relevant. What emerges? That this 27/7/2005 sent under annexure F was sent as a courtesy to the owners before submission to the authorities for sanction.
Yes.
So these were the building plans sent by him. Then the lordship will be pleased to see what is the documents actually filed by the petitioners in the arbitral proceedings, page 44.
List of documents.
List of documents. Letter from so-and-so to so-and-so to everyone, copy of email, copy of email, copy of email, letter by second respondent by email, copy of email, copy of email, letter by so-and-so to second respondent, copy of letter by second respondent to so-and-so,
letter by so-and-so to so-and-so, letter, email, respondent, email, letter, enclosing copy of conciliation agreements, copy of court proceedings, plaint, WS, so-and-so, so-and-so, Tata certificate, Tata transfer. The very same letter dated 27/7/2005, which is such an important letter, under which he is supposed to have sent the building plans, he does not produce it to the tribunal.
So 27/7/2005, letter was not produced.
Not one of these 16 documents which I just showed your worship is the letter dated 27/7/2005.
Before arbitrary tribunal.
Yes, before the tribunal.
Yes.
They had already produced as exhibit C.
What I'm trying to
So
say.
I agree to produce what
Yeah,
I had produced.
but we make out your case first. You haven't tried to make out your case. We will try to make out our case.
I'm sorry. I'm just clarifying.
Yes, we'll come to that.
So these are all the list of documents made available before the tribunal.
Before the tribunal. I reiterate to you what the points of determination were, what the scope of his evidence was.
Correct.
Building plans, which he now contains, exhibit C61 to C68 or some kind of building plans, not the full building plans, now permit me to produce it, is unfortunately belied by his own assertion in his affidavit that that was the plan that I wanted to courtesy show to the owners and submit to the BBM.
Yes.
Now let us take this cross-examination in the arbitration. I take the lordship straight away to page 39. I'm sorry, para 39.
Para 39. As per terms of contract.
Para 39.
Page 29.
Page
29.
starts at page 29. As per the terms of the contract, principle C3, it was my responsibility to obtain a sanction plan. Witness that was subject to claimant's legal authority to do so. It is true, I have stated in my affidavit para 5, the GPA general power of attorney dated so and so had been executed by the owners. Witness that power of attorney had been executed the parties filings to the JDA. It is true that all the parties to the JDA have executed power of attorney so and so in my favor. It is true this power of attorney has been executed in my favor as per terms of the JDA. It is true till today, no sanction plan has been obtained as per the terms of the JDA. Witness adds, I was never permitted or allowed to go ahead and submit the plan, in spite of the plan having been given to the claimants for their signatures for submission to BBMP. So where is the question that those plans which were available before the tribunal were Pacha plans, and today he wants to produce Pakka plans? Clear admission on the spot. What I gave in 2005, the signature is what I wanted to submit to BBMP.
Yes.
It is true as per terms of POA, Exhibit P4 Para A, I was permitted to obtain the sanction plan. So he had both signature ready plans, submission ready plans, and a POA to submit the plans, which he does not do. The next, page 29, if your lordship comes. I'm sorry, para 40, at page 32. What all he says about plans? Para 40, page 40.
It is true that
He does not produce the plans now. We produce it, confront it to him and get it marked exhibit C1 to 68, and today he wants to produce it. Last few lines of para 40.
it is true the papers.
It is true that papers exhibit C61 to C68 now shown to me were sent by me to the claimants. It is true that other than these plans, exhibit C61 to C68,
No other plans.
no other plans were sent by me to the claimant. I have sent to each of the claimants one set of each papers, exhibit C61 to C68. It is not correct to state that on 17/11/2005, one set of these documents were sent to so and so along with exhibit so and so. It was sent in July 2005 to so and so. It is true that exhibit C61 to C68 do not contain measurements and specifications, but I add they contain all the necessary measurements. It is true that they do not contain any specifications. It is not correct to state that C61 to C68 are schematic drawings. It is true that C61 to C68 cannot be called as final drawings to be submitted to the authorities for sanction. So he keeps on contradicting himself. Because now he's trying to wriggle out of the fact that he did not make plans for sanction. Because he knew where the case was now leading to. Because our case was that he did not prepare the plans.
Yes.
But originally, to make it seem that he had performed his obligations, he says, I have given sufficient ready plans for signature.
Yes.
Right? Then your lordship goes to page 44. I'm sorry, para 44, page 35. It is true, exhibit C34 is a letter written by me so and so on February 15, 2006. It is true, I mentioned it in exhibit C34, shared the idea to pick up hotel in property. It is true that plans for construction of hotel in this plot have been incorporated in exhibit C. True that plans for construction of hotel in this plot have been incorporated in C61 to C68. It is not correct to state that after shelving the idea of putting up a hotel is mentioned in the exhibit so and so, dated so and so, I did not prepare any fresh plans in relation to this property. I have not got these plans, nor have I produced them before this tribunal. I did not make available those revised plans to the owners or show to them those plans. It is false to say that those revised plans do not exist.
Denied.
When are these revised plans? 2006. Whereas what he says in his application IA-10 are the plans of 2005. So even today, what he wants to produce are not something that is somewhere available with somebody but not produced. Because he still refers to the plans of 2005 and not the plans which he is supposed to have done after 2006 by saying it is false to say that those revised plans do not exist. So our case is very clear, this case is very clear, we are talking about 2005 plans. Then again your lordship will see, para 59, page 41. Para 59 and page 41 of my copy. It is true exhibit R2 to R4 are letters addressed by Mrs. So-and-so to his family members. Those letters were delivered to Mrs. So-and-so. It is true that exhibit R6 and its enclosures are the same as exhibit R2, 3 and 4. It is a fact that the plans referred to in exhibit R6 and R7 are and which have been produced by me before this tribunal and have been marked as exhibit C1 to C68. So it is now well established. The only building plans in existence are before the tribunal in exhibit C61 to C68. Nowhere does a learned friend's case come within these parameters. That we didn't have an opportunity or that the necessary or relevant. It is all available before these.
Tribunal.
Then your lordship would also be pleased to see what he reads in evidence in AS 47, in the section 34 application.
Yes, sir.
Para 19 of this affidavit,
page
55, in his section 34 application,
I got detailed plans prepared.
I have got detailed plans prepared, had them circulated to corresponding to 105, letter dated so and so, exhibit C26, the same exhibit, annexure 4 before your lordship in the petition, 27/7/2005. the respondents with some excuse or the other by various letters exhibit as per exhibits mentioned in para 9 above have deliberately dithered on the plans prepared by the plaintiffs and have not arrived at any consensus, and as such plaintiffs have prevented the finalization of the plans to enable a billing plan to enable submission to PBMP.
Yes.
And it goes on to say, plaintiffs agreed to accede to all their demands, but insisted that particularly one person be given all the instructions, etc., because there were 5 and so on and so on. Now, my learned friend has also briefly adverted to the sequence of events in which things are happening.
Yes.
He files his affidavit evidence in 2010. Award is passed in 2012. Within about 12 or 15 days of the award being passed, last working day before summer vacation of 2012, AS 47 is filed under section 24. Yes, there were delays in the defendants filing their WS, but that WS, my learned friend pointed out, was anyway filed in June 2017. The fact of the matter is also, I know for a fact in Portal 11, where the matter was pending for about 1.5 years or 1 3/4 years, there was no presiding officer. But that apart, fact of the matter is, June 2017, we filed our WS. He consented it to being allowed. It was allowed and cost of 500 rupees. WS was taken on record. July 2017, they filed their application to lead evidence, which is permitted, and then they filed this affidavit from which I read. We are cross-examined. Naturally, we have then said, we will also lead affidavit evidence. Tomorrow, Section 37 board should not say that when he had the opportunity to lead evidence and establish a case, why you do not do so. So, by way of abundant caution, we also decided 2019, we filed an IA. Between 17 and 19, there was some other ancillary proceeding. Some other interloper had filed an application for impleading in the AS 47. So, by the time that application could be heard, etc., there was some time lag. Anyway, 2019, we got into the witness box. DW1 leads his affidavit of evidence, extensively cross-examined. DW2 gets into the witness box, extensively cross-examined. Matter is posted for final arguments. It is at that stage.
Present application.
IA 10, 11, 12 are. From what I could make out from my learned friend submission, subject to correction, my learned friend has not touched upon IA 11 and 12. Though, but so those orders are under challenge here, right? No, I have explained what to do. Okay, fine. And those orders are also under challenge.
Yes. The last few paragraphs of the orders under IA 11 and 12.
Same thing will be.
Yes, the only thing is that I just pointed out saying that he says the delay, because of the delay, you should have equivalence close to 2017 in 2021. This is a clarification even before it was posted for arguments. I find IA.
All right, fair enough, whatever it is. Now, I would like to take your lordship to IA 10, filed by my learned.
It was after closure of the defendant's evidence.
Yes, well, whatever it may be. The fact is, after all the evidence is recorded, application IA number 10 is at page 107.
Yes. Not 7 of
WP.
Annexion G, Lord.
Yes, sir.
Annexion G.
107.
Yes, sir.
Application on all 11 rules and 16 of CPC, etc. Persons to be summoned. Mr. So and so, architect. Mr. So and so, principal. Schedule. That is the documents ought to be produced.
Yes.
Mr. So and so, plans drawn up in the year 1995 with regard to proposed development of property bearing on the so and so. Then the second witness, Mr. So and so, our principal architect, all plans drawn up in the
2005.
year 2005 for submission to BDM. For submission to BDM. But may I take your lordship, refresh your lordship's memory on
what he had said in his affidavit of evidence, para 14, at page 11 of my compilation.
Yes.
IA-10, he says, Girinder prepared plans in 1995. In para 14, fourth line, fifth line.
So ready by July 2005.
Girinder's plans are in July 2005, not in 1995. And Ravindra's plans in IA-10, he says, were drawn up in the year 2005. But the last few lines, he says, Supreme Court gave its judgment in 2008 July. Subsequently, to the good officer of so and so, Mr. Ravindra was engaged in the preparation of the plan. So even my learned friend's client doesn't even know which plans he wants to produce. When those plans were made.
95 or
95 or 2005 from the first person, or 2005 or 2008 from the second person.
Yes.
Which is why I contended in my objection statement
Yes.
that at all stages of the case, from the time of reading this evidence in 2010 till the closure of the evidence in 2021, they knew very well that these building plans were of the utmost importance. And at no point of time choose to produce either themselves. Only a half-hearted attempt is made to confront so-called plans which are supposed to have been prepared to DW2 and say, these are the plans I prepared and produced at C61 to C68. Are these not the plans? She rightly said, I've never seen these plans, they don't bear a date on it. So my respectful submission was that when they had the full opportunity, they failed to make use of that opportunity. And we even doubt whether those plans even were in existence or not at all between the period 2012 and between the period 1994 and 2021 when this application came to be filed. Which is why, in my objection statement, I specifically contend it appears to us this is nothing but an attempt to make up lacuna in their case. Again, bringing it within this thing. Nothing but an attempt to make up a lacuna on the factual matrix of the case, not on issues arising under 34(2)(a).
Yes.
Therefore, my respectful submission, my lord, is that IA-10 was rightly dismissed by the learned commercial court. Similarly, IA-11 and 12 is produced, realizing architects cannot come to bring these plans. Petitioner decides he will come back. He will get the entire case reopened at the stage of final arguments, file an application to lead further evidence, and file an application to control the delay and produce exhibit C61 to C60. The learned commercial court judge has said, all this has been thrashed out in my order in IA number 10. This is nothing but an attempt to re-agitate the matter. There is a certain element of constructive res judicata. What you could not do to A and B now cannot be attempted to be done by C, and that for the very same purpose. And my learned friend has contended that the only grievance is that the learned commercial court judge seems to have made some observations in the impugned order, the second impugned order, on the merits of the matter.
H.
I just read two paragraphs, my lord, from the second of the orders at page 191.
So reason start at 183. Para?
It starts at 183. The
Para?
191 of the writ petition.
Para?
Para 18.
Yes, sir.
In bold, the learned commercial court judge referred to empty progress.
191.
Yes.
Yes, sir.
If is where we start. If the above decision
It's read along with.
is read along with the present case, though this court had granted permission to adduce evidence and having complied with the same,
The plaintiffs have lent evidence, closed their side as early as 2017, cross-examined BW1 people at length. How these documents could be produced for recalling BW1 to do away with the earlier admission before the arbitral tribunal. This is not the spirit of Order 18 Rule 17 to show the willingness on the part of the plaintiffs. Further, the plaintiffs on 17/1/2018, that is in Law OS 47, submitted before the court that they have no further evidence, and PW1 was cross-examined by all the advocates, and then Exhibit R1 to 13 were marked by confronting to PW1. Further, there is no whisper about these plans in his examination in chief. Therefore, I would review that the application for replea as well as recall of PW1 cannot be entertained at this stage, as PW1 never dreamt about it. If permitted to give evidence on the so-called plans, it is nothing but doing away by the admission by him, made by him. Further, there is direction order of the High Court to dispose of the matter with informants. Court could not do it on account of lengthy cross-examination and filing of IAs. Lengthy cross-examination was by my learned friend, because if the Lordship sees the very same order of July 2017, the day he got into the box, we finished his cross-examination also. We were fully prepared. There are no merits. Answer point number 2, the negative.
Yes.
My learned friend's only contention is that the learned commercial court judge seems to prejudge certain issues about the necessity for the plans, veracity of the plans, etc. That can be very simply answered by quoting the orders of the learned commercial court judge in IA 10, 11, and 12, and making an observation that he shall not be influenced.
Yes.
At the hearing of the Section 34 main matter, by any of the interlocutory orders first. In fact, such an observation is not necessary from your lordship, because every trial court judge knows that when they're passing final judgment, they should not be influenced by any interlocutory orders. But I think to assuage my learned friend's bruised case in this particular case, if an observation to that effect is made, I think everyone will be happy.
You're being very presumptuous in saying that.
Oh, that you're not bruised by it, then why are you in repetition? Why are you in repetition if you're not bruised by these orders?
There's nothing personal or not.
No, bruised in the sense of injured. Injured. So if you're injured, you'll come in repetition.
Very well.
So my respectful submission, nothing wrong with the orders passed by the learned commercial court judge.
Yes.
That's unfinished.
But I'll just take 7 minutes. I put the dates, my lord.
Still, you are harping on the maintainability.
Maintainability, I'm going further, my lord. I finished on maintainability.
Nothing else. Only on merits. Only in suffering impugned order. Very well.
2012, award is passed.
Yes, sir.
Thereafter, they filed this application.
21-5.
Yes. What is significant is, my lord, the petitioners before my lord invite an order on 1/8/2019. And on their submission, this honorable court directs the trial court to complete the proceeding in 4 months.
Where is that order in the
Sir,
in the?
I find the list of documents.
That he has produced it.
Yes, sir. That's why I did not
They
find
have
it.
gone to produce it. I have produced it for a separate memo. That's at page 4.
That is yours, sir.
Yes. Page 4, paragraph 2. After arguing the matter to some extent,
Yes.
learned counsel to the petitioner submits that the writ petition be disposed of the direction to the trial court to dispose of proceedings. He invites an order and his submission. Then my lord gives to see page 5. Arguments have commenced on the main.
Yes.
So my lord, that is one aspect. The second aspect, my lord, is that is from 10/12/21, is item number 4. This order is passed by the learned single judge. This present order.
Yes.
Is imbued here.
Yes.
Then 24/12, 24/1/22, another order is passed. Thereafter, my lord, on 1/2/2022, an application is filed by him for adjournment. He doesn't come to this honorable court. My lord, limitation is one aspect. Limitation can say that it's extended. But if somebody is in urgency of a remedy, they will rush to the honorable court. They will not wait to start final arguments and then want the clock to be turned back. Then my lord, please see 11 to 2022, again the matter was adjourned. Then 28 to argument start. Then he comes before the Honorable Court. My lord, I came across one judgment recently of the Supreme Court, Punjab State Civil Supplies Corporation, which says that para 11.
1 minute.
Because what my submission is, my lord,
Para?
present attempt of the petitioner before my lord is to convert the proceedings under section 34
Into
a first appeal. And the nature of application filed by him is in the nature of order 41 rule 27.
para 10.
Para 11, my lord.
Yes.
Here what Honorable Supreme Court says, while considering a petition under 34, it is well established, the court does not act as an appellate forum. The grounds on which interference with an arbitral award is contemplated are structured in the provisions of section 34. The district judge has come to the conclusion that there was no warrant for interference by the High Court. The High Court seems to have proceeded as if it was exercising jurisdiction in regular first appeal from a decree of a civil suit. Now, this is exactly what the petitioner before my lord is doing before the city court, saying that, look here, there is an arbitral award passed. Now, order 41, rule 27, some fresh evidence I have collected. Now, please adjudicate it. That is what he is doing. What the Honorable Supreme Court says is not permitted. He is converting the 34 proceedings into a first appeal.
Section 96.
Yes. The jurisdiction of a first appeal arising out of a decree in a civil suit is distinct from the jurisdiction of the High Court under 37 so and so challenging the award. This is one proposition from my lord's consideration. The second aspect, my lord, is that I produce another compilation, my lord, of this Bhavan construction where the 3 judgments, which I said
in the compilation,
rich jurisdiction.
In the compilation, so yes.
In that first compilation, Bhavan construction.
1 minute.
Yes, ma'am.
Yes.
But before looking at this, my lord, please see section 34(2). Section 34(2) of the Arbitration Act, prior to amendment, says furnishes proof.
Correct.
Now it says on the basis of the
records.
Now we can all agree that furnishes proof could be the example or could be the law which is applicable. Now we have 2 judgments on this point. One is FISA, one is Canara. Now both FISA and Canara Niti says furnishing proof, not what was not before the arbitral tribunal. A lot of well aware MS Gill case was election commissioner. An order is not like mines, where we can improve it over a period of time. Here there is an award. That award has all the material. Now, if I feel that that arbitration proceeding was conducted in a manner which is not, in my opinion, not in accordance with law or the procedural order, I have one opportunity. That opportunity comes under subsection 4 of section 34, where I can file an application before the court and say, please adjourn the matter. The court will then adjourn the matter for, say, a day or so. I will go before the arbitration tribunal. I will file an application to say, sir, this evidence has not been considered by you, or this material has not been considered. Sometimes parties may not even need evidence. Now, at that stage, my lord, the arbitration tribunal has 2 options. A, you can say, okay, you have now come, I will record your evidence. So that defect which is going to be pointed out under subsection 2 of 34 gets cured. Alternatively, the arbitral tribunal can say, look here, as per your conduct, as per the procedure, I am not going to modify, change my stance.
Yes.
But that opportunity comes under subsection 4 of 34. So to put my submission now, one aspect is converting this section 34 into an appeal and filing this application in the nature of order 41 rule 27 is a stage of final hearing which is not permitted. Second thing, my lord, the proof as per FISA and Canara Niti is not to prove his case on merits. It's to prove why the arbitrators are wrong.
Yes, sir.
Now he produces a document which is not before the arbitrator. He brings a witness which is not before the arbitrator.
Yes.
So now he wants a fresh innings. He's been knocked out.
Yes.
So his innings is over. Now he cannot come again. Therefore,
Yes.
my lord, in that context, what I submit is his conduct.
Yes.
The petitioner's conduct does not merit consideration of a writ being exercised in his favor. That is Bhavin's construction.
Which para? Which para?
My lord, that is at page 30.
1-3.
Yes. Sorry, before the page 11. Page 11, before para 18.
It is therefore prudent for a judge.
Yes, yes. The power needs to be exercised.
This I read it, I think.
Yes, yes. So that is whether he is entitled. Then my lord, Canada lady, I think my learned friend would provide Canada lady. So I'm not going to trouble my lord. I want to show to my lord Kinari Mulek, which was insofar as scope of 34.4, it starts at page 38.
Correct.
Please come to page 44, my lord.
Scope of 34.
Yes.
Para?
Yes. 44, para 15. On a bare reading.
On a bare reading of this provision.
Yes, it is on a bare reading of this provision, it is amply clear. The court can defer the hearing of the application under section 34 for setting aside the award on a written request made by a party to the proceeding to facilitate the arbitral tribunal by resuming the arbitration proceedings or take such other action as in the opinion of the tribunal will eliminate the grounds for setting aside the award. The quintessence for exercising power under this section is that the arbitral award has not been set aside. Further, the challenge to the said award has been set up under 34 about the deficiencies in the arbitral award, which may be curable by allowing the arbitral tribunal to take such measures which can eliminate the grounds for setting aside the arbitral award.
Yes.
No power has been invested by Parliament in the court to remand the matter to the tribunal except to adjourn the proceedings of section 34. The McDermott said. 16 is in any case the limited discretion available to the court can be exercised.
That was referred to after amendment.
No,
34.
this is the
34.
34.4.
5 and 6.
Yes.
5 and 6 is amended.
34.4 was all. 34.4 was all.
It was there. Yes.
34.4 was from inception.
It was there.
Yes.
On receipt of application.
Yes.
Correct.
So no application. Yes. It says in case a limited discretion, only upon a written application by the party to the arbitration proceeding.
Yes. Yes.
Crystal clear court cannot exercise the power suo motu.
Yes.
Now there is no such application. And I already submitted.
Even otherwise, I think just subject to your clarification, I think legal issue. At most, what the court under 34 can do, you can set aside and remand.
No, the latest judgment, the latest judgment of exercise,
it only can set aside, it cannot remand unless both parties consent. If both parties consent, I don't think my learned friend will disagree.
No, I'm sorry. The latest judgment of the Supreme Court says differently. There is no question of remand also.
Set aside.
No, set aside,
Leaving the parties free to do
whatever.
That's correct.
That is nothing else.
Go back to status quo, I agree.
No, with regard to remand also.
Because earlier judgment.
Yes, earlier to now the latest judgment says section 34.4 only with the consent of both parties, not even on an application. That's the latest February judgment.
Anyway, the law as was when my learned friend was on his legs before the court below. He could have, but he has not.
No, that is earlier. I talked about
Yes, Sajid. Next.
Therefore, my lord, most respectfully,
yes,
the conduct of the petitioner
has to be looked
at. That's all, please.
May I just supplement what my learned friend just said on the petitioners trying to make a section 34 into a first appeal under
96.
Even under order 41, rule 27, assuming this was a first appeal,
CPC, the lordship sees, it is not as if he has an absolute right
That's good.
now to, at any stage of an appeal, say, I want to produce this. The parties to an appeal shall not be entitled.
Yes.
Is what the reading of Order 41 Rule 27 is.
41 Rule 20.
The parties to an appeal shall not be entitled to produce additional evidence, whether appellate, whether oral or documentary, in the appellate court.
The parties to an appeal shall not be
Shall
entitled
not be entitled.
unless.
Unless, but if A, the court from
So
whose
fulfill these
has
aspects.
refused to admit evidence which ought to have been admitted, which doesn't arise in the instant case, because before the tribunal he never sought to admit it. On the contrary, he was forced to admit it in cross-examination, that was it. B, sorry, double A, the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not
Available at the time of.
or could not, after the exercise of due diligence, be produced by him at the time of the decree appealed against was passed. Where is the question that it was not within his knowledge? When so many times he has admitted in his examination in chief before the tribunal and in his cross-examination to the tribunal, those plans existed, chose not to produce. So even if this was an appeal under Order 41 CPC, the first appeal with a very vast scope, he still would not be entitled under Order 41.
It shall come within the purview of A, and B.
Yes. And again, B, appellate court requires any document to be produced or any witness to be examined to enable to pronounce judgment or for any other substantial cause. With great respect, my lord, and the higher orders passed on IAS 10, 11, and 12, the learned commercial court judge has come to the conclusion under B also, I don't need your documents to consider the decision.
So because why the 41 Rule 27, if you look at the legislative intent, because the first appellate court is the last court for finding of fact.
Yes.
That's why it plays a judgment.
Then, the last sentence of Order 41 Rule 27 Rule 1 says,
yes,
the appellate court may allow such evidence, not even shall, just because you satisfy these two conditions or three conditions.
It's a discretion.
It's not a question you shall. Even if you satisfy, still appellate court may say, no, doesn't matter, we don't want it. Exactly what the learned commercial court judge under 34 has said, I don't think it's necessary for these documents to come for me to know whether this award is bad in law or not. Not as to whether you made out a good case or bad case before the tribunal.
Kumar Sahib on 41 Rule 27, entire thing.
Yes.
Yes, sir. Next.
I don't know. The only person who knows the facts from beginning to end is my lord. Because he's been from the beginning of the case before the tribunal.
He was the author of the case.
No, I was the author of the termination notice of 19th October 2006.
Every date in
Yes, sir. So you narrow down your arguments as such.
Yes. I'm only continuing what has already been submitted.
Yes.
That is taking it from visa onwards. I'm only producing one judgment. This is the latest, my Lord of Justice Rohit Marina. May I take
That's
your
a Gemini Bay.
Huh?
Gemini Bay. Gemini Bay transcription.
Gemini.
Para?
Yeah. I'll just the lower page 8 at starting page.
Para?
Paragraph
12.
Just to say how.
Just a minute. Where are you reading?
Can I get a page 8?
The para,
Paragraph
12. 1 minute. The learned arbitrator.
Yes. The date of the award is 2008. Pre-amendment, post-amendment, how does the Supreme Court look into it?
Yes.
Now, may I take your lordship straight into, can you get page 18, paragraph 38.
Page 18.
18. Can you get a page 18? Because this seems to be a
Yes.
page of.
Yes, sir.
We now come to section 48, which deals with the enforcement of a foreign law in the
Para 38.
38.
1 minute. Yes, sir.
No, before that, I'm sorry, the previous page, paragraph 37.
Yes.
37. From this, it is clear that all the requirements of subsection 1 are procedural in nature. Procedural why? Because a procedural amendment is retrospective, a substantive amendment is prospective. Now to see what the Supreme Court says, this is paragraph 33.
We now come to section.
We now come to section 48, which deals with the enforcement of a foreign award being refused. It is important to notice that when the enforcement of a foreign award is resisted, the party who resists must prove to the court that it falls within any of the clauses in subsection 1 or subsection 2 of 48. Since some arguments were made as to the expression of proof contained in section 48.1, it is necessary to deal with the same. Same MK is also referred to.
Yes, referred to.
Now coming to 49. The entire case law is discussed.
Yes.
Paragraph 49. Given that foreign awards in convention countries need to be enforced as speedily as possible, the same logic will apply to section 48, as a result of which the expression proof in 48 would only mean established on the basis of records of the arbitral tribunal and such other matters as are relevant to the grounds contained in 48. It is important to remember that the New York Convention, which our Act has adopted, has a pro-enforcement bias, and unless the party is able to show that it comes clearly under 48.1 or 48.2, the foreign award must be enforced. Also,
yes,
the grounds contained in 48 zones are not to be construed expansively but narrowly.
Yes, sir. Brief reply. Brief reply.
I don't have.
Lord, also, if I may just submit in relation to the median collecting. On the other day, I had just said there is an imperative clause in CPC, which is order 43 rule 1 capital A. All along from 1977 to today, we have had an alternative, but we have been filing GMCs. The question becomes, when the alternate remedy has been made available, I am actually supporting the petition. When the alternate remedy has always been available to us from 1977 to today, why are we coming in a petition? The submission is because we require two ingredients. One is alternative, the other is efficacious. While alternative is available to us under 43 rule 1A, the question is whether it is efficacious. My submission is this: I would rather have a closure on every interim order and finally go only in the merits of the matter, than for me at the end of it or to come before this court and the appellant bundle up all his grievances and throw it to us in the appellate form. Is that efficacious to come with us? My submission is no. The reason is because of this. If your lordship actually looks at the number of NFAs, writ petitions, CRPs, which actually have been allowed and sent back, imagine how much judicial time you will waste when everything is completed. We come and appeal, some small, and go back every month. So it's not efficacious. Alternative may be,
but not efficacious.
not efficacious, and therefore a writ petition should be maintainable. We should come, crash it out of here, have a closure, and go only for them. This is
yes, yes.
Like,
Please.
Tomorrow.
Wait.
I just,
because today we have a full court meeting.
so tomorrow I
5 o'clock I have.
No, 5 minutes I'll take tomorrow morning itself. Let's start this. Because I just want to clarify some factual aspects. Let it not be felt as if I am the
2:30. Possible 2:30.
2:30.
Because I don't want to
Yes.
interfere with
Yes,
the
5
regular
minutes.
list.
I will finish it and then go to the other.
2:30.
I have answers to it.
And what I'm all of you requesting to just file a synopsis.
Synopsis. I also need the reply in the synopsis.
Yes. Are you able, if you file it by tomorrow,
Tomorrow I'll give it across the bar.
Suppose
We'll endeavor.
because what has happened, most of the cases in which the similar rights of arguments will be addressed. Then sometimes we say that someone, I think, that's it.
K.T. Thomas's judgment, 2001.
Which one?
Justice K.T. Thomas's judgment.
Ah.
Certain times judges were they get mixed up.
Yes, definitely. So 2:30. Right. Only insofar as reply is concerned.
Yes, for reply. Unless my development comes up with some new facts.
No, no new facts. No new facts. I'm only going on based on what. Great.
Unlike Exhibit 61 to 60.
No, it's the same exhibit only. I'm not going to be very Interim order can
Extended
be
till next setup.
Great.
Chamber, South Chamber.
Great.
Namaste.